your birthday during the other than work?
Oh, yes, my birthday is on November 2nd. So, land of the living, land of the dead. But I celebrate the entire month. I think everybody should celebrate their birthday the entire month. All right, so everyone, I'm going to call the docket. When I call the docket, you need to let me know that you are here. If you don't answer, I'm going to assume you're not here, in which case a warrant may be issued for your arrest. And I am going to give people a little bit of leeway for being late, even though I'm on time. But I know it's raining outside, and I would prefer that people make it safely as opposed to rushing and perhaps not make it safely to their destination. But the rain is good because you don't have to water the grass. Deputy Laura, should I talk about the LSU Tigers? So my birthday is complete, the fact that they won. So I'm good. All right, so everyone just give me one moment. It's probably going to be 90 degrees tomorrow or something. All right. Oh, just have a seat. Okay. All right. See, guys, women, it could be your mother, your brother, your mother, your sister. They always try to make sure that the males make it to court on time. So we should thank women today. So, all right. Samuel Ramirez. In custody, we have Paul Duncan. Oh, you're not in custody. You're in bond. All right, thank you. In custody, we have Jaime Santos, Eric King, Robert Beltran, Angel Cantu, Tracy Fitzpatrick. Is there Isaiah Gonzalez here? Isaiah Gonzalez? Maria Medina. Maria Medina. I think we're going to have a lot of late people today. Isaiah Verju. How do you pronounce your last name? Verhu. All right, thank you. Jasmine Hardaway. Brandon Wright. Brandon Wright. Robert Reyna. Thank you. Philip Diller. Thank you. Jesus Solis is in custody. Andres Diaz. Dario Escalante. Dario Escalante. In custody, we have Crystal Cherry, Armando Jimenez. Ernesto Lozano. Ernesto Lozano. Tyrone Laird. Brian White. In custody, we have Jorge Ortiz. Jenna Rodriguez. Thank you. Justin Lamb.
If he's running late, Your Honor, that's a PTD contract signed and filed last week.
All right, thank you. In custody, we have Jason Hickman. Gloria Orozco. Thank you. Oh, I was like, is my vision off or is his face covered? All right. Joe Lopez is in custody. Veronica Alvarez. Veronica Alvarez. And then we have R.C. Curtis. Alejandro Black.
President, downstairs should be up.
Thank you. In custody, we have Rudy Gonzalez, Jonathan Ruiz, Julian Martinez, Julian Reyes, Carlos Villegas. I got my double L's right. Caleb Coleman Lee. Caleb Coleman Lee. Manuel Sandoval. Angel Galindo. Angel Galindo. Kino Jimenez. Kino Jimenez. Rafael Guerra III. Okay, see, this says Raphael Guerra III, but then it has Junior by it. I have questions on that. All right, is there anyone who came in late or your name was not called? All right, thank you, Mr. Black. All right, everyone, so these are the rules of the court. This is a courtroom. Everyone, please make sure that you're not talking loud when the court is on the record because it makes it difficult for the court reporter to hear. When inmates come out, if we are on the record, do not talk behind the court reporter. If you need to have your client move, just ask the deputy and they will accommodate. There are boxes to my right and boxes to my left. On this side is family violence or special crimes. On this side is criminal trial division. So your boxes are on either side. I like to keep the court as least congested as possible. I feel that when it's not so congested, things tend to move more efficiently. So just grab your file. If you'll place it on the desk on either side, the prosecutors will call you in the order in which you'll appear. So in this court, first is first, last does not become first, the middle does not become first. Once you have conferred with the state, if the state is able to give you an offer, you need to give that offer to your client, confer with your client, and do not approach the court until you've done that. If your client is in custody, do not approach until your client is brought out. Then just go to the clerk, ask for your file to be placed up here. They will place your file up here, and then the court will call you in order in which I receive your file. If you have a client who's in custody, just ask the deputy to bring them out. Do not leave the courtroom when your client is being brought out because we have two deputies. They're working hard. They're trying to make sure your clients are here on time for you, and that'll make everything run smoothly. So it's Monday, it's raining. People usually don't want to be to work on Monday. So we're going to put some extra patience in our pocket. For the guys who have suit coats, I know there's a third pocket built in your jacket, so put some extra patience in that. Pull it out as needed. And everyone, let's have a great Monday. Please confer. And Mr. Moray, if you want to call Mr. Bonk and see what time they have Mr. Curtis for us to start on that. Whenever you all are here and ready to proceed, I'll hear your argument.
Okay. Dana responded to a text. She said 9:30 is where.
Okay, sure.
So I'm just gonna sit tight.
All right, thank you. Hey, Nathan, you can sit tight and help prosecutors and everyone. Brenda, do you think Mr. Cox is going to come and celebrate the LSU Tigers?
Sometimes he should.
Yeah, he should. I'm like, come on.
He would.
Yes. Deputy Laura. Thank you.
Oh, it's good.
No, I said no.
The last.
All right, Lupe, on this, instead of saying 99 years, it should say life. No.
Yeah, that's enough right here.
Oh.
Where are we? When the money is in.
initially, they were up on the thing that.
Yes.
Maybe it was two.
So did you email him? Thank you.
Alejandro Black, both of us are ready to put them.
Know what I'm saying? Here.
All right, Alejandro Black.
Yes, ma'am.
Good morning.
Good morning.
I'll just see where we are.
He's on the recall.
All right, so on this case, counsel, you received all the discovery.
To my knowledge, Your Honor. We raised the prospect that police had been called out previously, had the DA's office look into it. They said they couldn't find anything. So, other than that, yes.
All right, Brendan, can you see what page Mr. Black is on?
He's on the recall.
On the recall,
Yeah.
okay. All right, so what did you want the state to look into?
Previously, I had discussed that there have been other interactions between the parties involved in these cases, and we asked them to look into whether officers had come out. They had stated that they weren't able to find anything. The court asked me whether or not I felt it had been complied with. I believe them when they said we looked into it. My client does say he's had interactions with law enforcement regarding this neighbor before, so there's some disconnect there as
Well,
to,
have there been police reports before?
that's my understanding. Yeah.
All right,
Nasty.
if your attorney wants you to speak.
Yeah.
Okay, so the last time they came out, we asked them to make a police report, but he told us we would have to come downtown and fill it out.
So did you do that?
No, ma'am, we never came downtown.
Maybe a report, even an incident detail report usually would have been the system for the address though. So
All right, all right, State, did you look to see if there were any incident detail reports or just for police reports?
Yes, Judge, our investigator ran it and wasn't able to come up with anything.
Okay, all right, so State, you've made an offer
Yes, Judge.
and you're rejecting the offer, you're requesting a jury trial?
Yes, ma'am.
All right, have you considered a bench trial or no?
we
Or
asked
I don't
for a
know if
bench
you all
trial.
have conferred on bench
We
trials.
asked for a bench trial, the state objected.
Oh. That's okay. Everybody's entitled to a jury trial. This is what we're going to do because we actually have a capital murder trial that's upcoming. So your trial is going to be pushed back. It's probably going to be pushed back to maybe the new year because
There's a lot of.
the capital murder trial is in November. And I expect that that's going to take no small amount of time because I'd like everyone to have the amount of time they need to try their cases. And then, as you know, nobody wants to try case on Christmas Day. Now, if Brenna, if you want to be here on Christmas,
I don't think my
Brittany?
kids would like that.
I mean, where the children understand that.
Okay, no.
Well,
Britta's already gonna be mad at me.
Yeah.
Say I talk. I don't need her double. Fist on,
will I be seen as the Grinch?
Let's not do
Christmas will not come to Hughes or something.
that. Yeah, let's not do that.
Yeah. All right. So what I'm going to do is I'm going to give you a date. I'm going to give you a December date. But by that December date, we should have an idea of how jury trials are set up. So that's why I'm giving you the December date. So know that this is not a trial date. This
If
is,
it's like that, can we excuse him from work and I just be here?
well, he can be by Zoom.
Okay.
Yes. And just remind me so I can give you the Zoom link. So we're going to bring you back on December. Let's do December 5th. Okay. Do you have any off days?
I'm a subcontractor, so I'm off whenever I need to.
All right. So we can do it on December 5th and you can, and I'll put a notation in the file that you can appear by Zoom. Let me give you.
Doesn't know he can take off when he needs to, but he also has dependents he's taking care of, et cetera. So to kind of keep him from taking off if he has to.
All right. So we'll do December 5th
This is not a trial. So
and you can just put other, and for other, you can put confer. We'll put it as confer, even though I know it's for a jury trial date.
Understood. Thank you, Judge.
All right. Is there anything else?
Nothing at this time.
All right, then you are excused.
Thank you, Judge.
You're welcome.
Congratulations on the win. I know that's not happening.
Yes,
Alejandro Black.
it's a 2022
I got it.
2567.
And anybody in the FEC is always happy when Alabama gets knocked off.
Although my heart was racing when they decided to go for 2 points.
Mhm.
And people were calling me before the clock said 0.
Celebrate before zeros.
I'm like, no,
We're
so
trying to jinx us. What do you-
yes. Just give me 1 second. All right, Norma on Alejandro Black. He's coming back on December 5th, just for him to get a jury trial date and he can appear by Zoom. Okay, here you are. All right, Ms. Thorne,
I apologize.
I like your pen.
Oh, thank you. My client, Veronica Alvarez.
Yes, I have the file. So she was previously a no-show.
She's a no-show.
And is she still a no-show?
She's a no-show, Your Honor, and I have no contact information for her, and then when I called the bondsman, they don't have their file on her.
Okay. All right, so we're gonna take this matter up then. Brenna, are you ready?
I'm ready.
All right, could I have someone from the state? It's Criminal Trial Division. Court is calling 2022 CR 9445, State of Texas versus Veronica Alvarez. Could I have parties announced for the record for the state
Brittany Sparks.
defense?
Sharon Thorne, the defendant.
All right, this hearing was scheduled at 9 a.m. The court does realize that there was some weather issues, but this is a case where it was originally set for November 1st. The defendant was a no-show at that time, and the court had the case recalled for today to see if Ms. Thorne, you would be able to get in touch with your client and to see whether your client would show, and your client is not present and not in the courtroom and did not answer docket. Have you been able to discover where your client may be?
No, Your Honor, and in looking up the appointment order I have.
Okay, so you guys are loud. Okay,
No, Your Honor.
yes.
The appointment order I have doesn't even have a phone number, but it has the name of a bondsman. And contacting the bondsman, they can't find their file on her. Your Honor. So I have no contact information and I have not been able to contact my client.
All right, Deputy Laura, were you able to announce for Veronica Alvarez?
Yes, I did, Your Honor. There was no answer.
All right, so according to the deputy, there's no answer for your client state.
Should ask that you forfeit her bond and issue a warrant.
All right, that will be granted if you are able to get in touch with your client and your client makes an appearance, then the court will reconsider.
Thank you. Your Honor.
All right, thank you. You may be excused. Can you check to see if that was a PR bond?
And what's the case number?
2022 CR 9445. All right, here you go. It's a BL.
I'm just gonna see the reset forms.
I haven't reset anything. Okay.
The last page has.
Oh.
I could change it to one.
Okay, all right, thank you.
It's not on. You'll get the phone. It's an MTR. I can give you this. Yeah, he's in custody. No, I don't. I get that, but it's. I'm in the. Not yet, the weather comes by. I just want to get with this. I've talked about this. It's SID number 464409. It's an MTR. Yes, ma'am. 025802.
Let me get myself some. Okay. Norma. On this thing, can you let Lupe know that that needs to be file stamped? Okay, thanks. All right, who is here on Philip Diller?
John Carr,
Thank you.
present, the president.
Yes. All right, how's your toe?
It's missing.
Oh, it's gone.
Yeah, they amputated it.
Ah, so was it the pinky? Oh, if you guys. So was it the pinky toe or the big toe?
The smallest one.
All right. You know, in Stripes, Bill Murray said the big toe was the captain of the toes. So at least it wasn't the captain. I hope you're doing better.
It's human.
Okay. So, Mr. Sharp, have you received all the discovery in this case?
Believe we have.
All right, so I'm gonna need a discovery acknowledgement done.
Yes, Judge.
And let me see where we are on the docket. Brenda, do you see Mr. Diller? All right, thank you. All right, so has an offer been tendered?
Yes, Judge.
And when was the offer tendered? Oh, I see it was tendered on September 13th.
That sounds right.
Okay, so, Mr. Diller, have you had ample time to consider the state's offer? Are you rejecting the offer? All right, so your plea deadline date has expired. Ms. Ferguson, can we get a jury trial date for Mr. Diller? And your jury trial date will be sometime in the new year. We do have a capital murder case that's upcoming, and it's probably going to take us into mid-December. Unless your attorney wants to be here on Christmas to try.
I can do January 10th.
Okay, I'm
You'll
taking,
be here, Judge, I'll be here.
oh, he says that.
Bring the whole family.
Oh, well, let's do it. He says that, but then if we're here, he's like, Judge, I didn't know you were serious. So you say January 10th? All right, so it's gonna be January 10th. Who would have thought we're now saying 2023?
All right.
You need to be here at 9 a.m. dressed for trial. A jury will be here and we will start your jury trial. All right.
Is that a special setting like with that?
I don't do special settings.
It's on the docket with everything else.
Yes.
except for trial, but we
Yes.
need to be ready just in case.
Yes. So, Mr. Diller, after today, if you decide to enter a plea, the court will not accept any plea bargain agreements without good cause. Otherwise, you'll have to plea open to the court. You understand?
Sure.
All right. Have a great rest of your day and be safe out there. The weather is bad.
I got my wife driving.
Oh, well, I know it's gonna be fine then.
Thank you, Your Honor.
You're welcome.
We're gonna sign this and then maybe be.
Yes, just turn that back in. All right, who's here on Russell Dean Henshaw?
Harshaw Judge.
Rushaw?
Yes, ma'am. I am Judge.
Well, what is the N is not pronounced?
It's an R. It should be an R.
No, it's HANSHAW.
Well, then then the indictment was. Anyway, it's.
Well,
Harshaw.
oh, this is what's on the motion to revoke, so that needs to be corrected. All right, because I was like, the N is now sounding like an R, Brenna.
Yeah, no, you threw me, Judge. I didn't notice. I didn't.
All right, so,
I spoke with you about 10 days ago that he had hired me. We were working on getting him down from, he's a Colorado native.
mhm,
He's got an MTR. And so he got picked up last week on the warrant out of Bear County. And so we're in the middle of negotiating to see if the state would entertain even jointly recommending bonds would get him down here quicker.
well, why don't y'all negotiate or see what the plans are with this motion to revoke?
Okay. Well, that's that too, Judge.
Yeah.
So.
So with regards to the bond, I mean, this is a conviction. So the court needs information about his criminal history in order to set this. But if you wish, you can go to the county magistrates. I know they have access to it instantly. And you can tell them that they have my permission to set the bond.
Okay.
Okay, and right now.
Well, he's in Colorado.
Yes.
No, what I'm saying is
But I
you want a bond. So
Yes.
if you want to talk to the county magistrates, the state, you all can confer. What I can tell you is they may not put it in the system until he turns himself in.
No, he's in the system.
Oh, he's in the system.
Downtown jail.
Okay, awesome.
This last one.
So yes, just confer, and if you all will call the county magistrates and let them know that, let Judge Ramirez know that she has the court's permission to set the bond, and she will.
Okay. All right.
All right, thank you.
Thank you.
Sure, and then just make sure you get a date from Miss Ferguson. All right, you're welcome. And you know, the bond, we can also have a hearing on this by Zoom
Okay.
with your client in Colorado.
He also has the Wilson County. So he was just finishing up his probation.
Ah,
Yeah, it's a mess, because the supervising attorney up there, probation officer sat on a whole bunch of 30s and never told anybody. And then suddenly everybody found out about it.
well, I mean, sometimes, you know, some things are better left unsaid. Isn't that the way the song goes? But we can actually have him zoomed in from Colorado if they have Zoom capabilities, which I'm sure they should.
All right. Well,
All right.
options. Very
All right, thank you.
Thank you.
All right, is there anyone here who's come in late? Yes, what is your name? I'm sorry, what? Did I see the file on Tyrone Laird?
You know, Hernandez just got here as well.
Who else is late? All right, why are you hiding your lateness?
I'm not, I just checking over.
Okay. Mhm. I'm sorry, I can't hear you and you're not standing.
I've been here for 5 minutes. Give it a chance.
Person's attention you should be getting is mine because you're late. All right, and Mr. Laird, you know you were not supposed to be late again. It's lucky for you that it's raining outside because I prefer for people to arrive safely than have an accident. Don't be late again. And I'm giving everybody a little leeway because it was raining, but guess who was on time for court today? Me. Right? Okay. And random right.
Thank you. Bye-bye.
Brandon Wright, who's your attorney?
So Charles Bunk.
All right, just give us a moment. I'm going to put you in the waiting room, but as soon as Mr. Bonks arrives, I'll bring you out of the waiting room, okay?
Yes, ma'am. Thank you, Your Honor.
And as soon as Mr. Curtis arrives, we'll take up the R.C. Curtis matter.
I mean, we can print them out today, but. I mean,
Hello,
Hi, Judge.
hello.
was late this morning.
Oh, okay. Well,
My client was on time.
all right. Well, thanks for acknowledging it. And Brenda, it is getting a little hot in here.
You want us to open the door, Judge?
Oh, yes, that would be awesome.
I did a good job.
Oh, good.
You do have that. I'm just waiting for payment. Give it to me. Okay. All right. Okay. All right. I have it. I kind of started it. It's not super long, so it'll be okay. But I just didn't want to forget about it. Finally have it. It finally ended last week. Guilty, I give her away.
Hello.
Cool. Are we waiting on Mr. Curtis himself?
Yes.
I have not talked to Mr. Bond about whether he's carried.
All right. So if Mr. Curtis can appear by Zoom or,
Yes.
I don't have any contact with him.
So,
All right, just, can anyone contact Charles and,
Thank you, brother.
yes.
yes,
Can you approach on a different issue?
Good.
Just making sure.
sure, what's the issue?
It's not, kind of, I just want to say something to the judge, but I want you.
Okay.
Can we approach this?
Yes, is this
Off the record.
off the record?
Yeah.
Can you mute us, please?
Sorry. Did they win this weekend? Good friend of mine used to coach there. He was the offensive coordinator until last year. Soccer team, Kelly.
All right, who is here? If you guys can contact Mr. Bach and see if he can get in contact with Mr. Curtis. Who's down? Andres Diaz? All
Charles.
Present, Your Honor.
right, and where is Mr. Diaz?
Right there.
Come forward, please. All right, thank you. Good morning, Mr. Diaz. Everybody's whispering today, or either my allergy ear is not making me hear anything. All right, so my understanding is you've received all discovery.
We have, at least that we're aware of, anything else.
Okay, as far as I know. Judge.
All
I
right,
think
so
we're good,
I'm gonna
Judge.
need a discovery acknowledgement done today. State, are you able to do that?
Yes.
Has an offer been tendered?
Not yet, Judge. The state, we just reviewed, there's some updates on what the complainant wants, and so we're gonna reach out to see if we can come to a resolution on it.
All right, and state how much time do you need for that?
Just do regular 30-day reset, Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Andres Diaz, please?
December 19th.
All right, we'll see you back on December 19th.
Thank you, Judge.
You're welcome. Just get a reset form from the state.
Yes, Your
I'm
Honor.
sorry, from the coordinator.
Yes, Your Honor. Afterwards, may we excuse?
Yes.
Thank you. Have a good one, Judge.
All right, you too. All right, who's here on Carlos Villegas?
I put a sticky on there, I think.
All right, do you have,
That's not through yet.
all right, do you have documentation?
He's coming from
Jail.
Oh, it's a jail. Okay, when do you want to call this back?
December 1st. Judge.
All right, can you let the defense attorney know? Mr. Cabanas, is your jury, good morning, is your jury trial done?
Jury downstairs.
Yes.
We'll see what we fall.
Ah, okay. All right, just let me know whenever you're ready to approach.
No, no, I'm saying, no, I'm not saying that. You have to live it, then it becomes right. Every day I wake up and I say, what word shots? What? Put it under. Put it in the pillowcase. My safety. The feature of the. Yeah, we're out there for a while.
One last time. May I approach, Judge?
Yes. Hello.
Oh, we're just waiting.
Yeah, yes.
I've learned never assume. I want to make sure that it's done. We're good to go, and then,
Oh, yes, you are good to go.
thank you, Judge. Have a blessed day.
All right, you too. Have a good one. Thank you. Thanks for wearing the LSU colors today. Bashan, I'm going to send you this email back on Anthony Jensen. For some reason, I'm unable to see the recommendations. All right, so I'm just going to forward it back.
So, yeah, my kids.
Kelly, hi. Do you know where, we're waiting on Charles Bond and
Yes.
Mr. Curtis?
Okay, so Charles isn't coming. I just texted him. He's in the 175th. We did not give RC the Zoom code.
All
So
right.
Natasha's doing it right now.
Okay, all right, thanks. Do
Okay.
you have the Zoom link?
We got it just at like 9:30 for Brandon Wright, who should be on there hopefully.
Yes, he is. He's in
Okay,
the
I'm
waiting
gonna
room.
confer real quick and then I'll.
All right. All right, thank you.
I just was told RC's getting on right now.
Okay, all right, thank you. But what if something happened with the case? What is the next court date? If he doesn't have a court, well, November 15th. So are they gonna have everything ready by November 15th? All right, tell them they need to have it by November 15th. Um, Oh, we'll just do.
I don't remember who they were playing, but they came down here, like, there was massive explosions.
You're welcome.
Downtown. Yeah.
My email's been active.
You should be on Wednesday. Okay, if she asks you. May I approach real quick on
Yes.
Brandon, right? I conferred with Michael. So basically there is an additional potential case that I hate when my arm is showing on the Zoom.
All right. So what is happening with Mr. Wright? There, last time we were here, there was a potentially new offense
Correct.
and
In that case,
new
Judge,
complainant.
I've been told it's gonna be just potential punishment, not an indicted case, but we still need discovery on it. And because it is an at-large case, they do not have all of the discovery just yet, even the state doesn't have it. So Michael's working on getting it.
Okay.
So once he gets it, then we can get it.
All right, Mr. Villarreal, how much time are you requesting? Oh, and Kelly, it's behind the line. I like you though.
Sorry.
That's okay.
No wonder it's like always just my arm.
Yeah.
Judge, I'm looking right now. I haven't followed up with it. There's two detectives because there's two separate cases. It doesn't look like they've turned over. There's a laptop that was taken into custody and
And there's probably something gonna be in the laptop potentially.
there's allegations that there will.
All right, so Ms. Ferguson, what I'm gonna do is I'm gonna give you guys a 45-day reset. It's rare that I do that, but I know if there's laptop search warrant and if there's extractions, it may take a while. So Mr. Wright, on your 45-day reset, that's just gonna be for discovery, for the state to give me information on where we are in discovery for both the state and your attorney. So Ms. Ferguson, can I have a 45-day reset on Mr. Wright?
Back on January.
All right, so we'll be back on January 5th.
Okay.
And Kelly, if you win the lottery, you must remain on this case. I will not release you.
Okay, Judge.
I got the fine first.
Okay to the 5th, not okay to.
All right, so we'll come back. Mr. Wright will come back on January 5th. And Norm, can you put on there that he can appear by Zoom?
Thank you,
All right,
Judge.
thank you.
Thank you, Your Honor.
And are the parties ready on R.C. Curtis for argument?
Judge, can we wait just a minute for Charles is doing a plea in another
Oh,
court.
sure.
And as
Okay.
soon as he is done, I'm gonna tell, he's coming up here.
All right, thank you.
May I be excused?
I just assumed this would come up for me.
Yeah, no, that's for you. It's like the red carpet, right?
I want it to be more like FaceTime.
I can't believe we're now saying 2023.
I know.
All right, who's here on? Oh, we just did that. Hello, Nathaniel. Hi, are you getting sleep?
Yeah, I think so.
So you think she's on a schedule now?
It's hard to remember how many times I wake up at night, but it's going all right.
She's gonna mix it up.
I don't
on
feel
you.
terrible.
Yeah. Well, at least she's at the stage when Christmas comes up. I think baby's just like the fancy wrapping paper.
Yeah. That's more important than the present.
All right, Robert Reyna. Hi, if you're gonna be zooming, you have to zoom outside the courtroom.
Yes, Judge.
Thank you. All right, who's here on Robert Reyna? Mr. Reyna, come forward. Okay, so what is happening with Mr. Reyna's case? I remember he had tongue surgery.
Yes, and what the last setting judge, he had COVID. I told him to wait outside the courtroom. They just reset his case, so we didn't really
Yes.
get to confer a whole lot on that. I would just ask for one final setting. We've received an offer to determine if we're going to accept the offer or take it to trial. If that's possible, Judge.
Okay. Do you have all the discovery?
I do, yeah.
All right, state if you can get the acknowledgement of discovery filed today.
Yes, Your Honor.
And Ms. Ferguson, can we have a plea deadline date for Mr. Reyna? Is 30 days enough time?
I think so, Judge.
30-day reset.
I can do December 19th.
All right, it'll be December 19th. And Ms. Ferguson will give you a reset form and then you are excused. Thanks for dressing appropriately for court. Right now, I'm trying not to jinx us. So I'm trying not to even think it.
Just let it pass.
You know, it's like the scene from Ghostbusters where they're like, clear your mind. And then he's like, the Stay Puft Marshmallow Man just popped into my mind.
Good morning. Hold on, please.
All right, who's here on Paul Duncan?
Present, Judge.
Oh, this is one where the state recommends.
Recommends just on a regular, yes, Judge.
All right.
And it's on deferred, oppose or silent.
Deferred is opposed. All right, the court is calling 2022 CR 5349A, State of Texas versus Paul Harley Duncan. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Scott McClung from Mr. Duncan.
And are you Mr. Duncan?
Yes.
All right, Mr. Duncan, you entered a plea on to count one, the lesser included offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. You entered a plea of no contest. We were scheduled on October 31st, but you were ill, so we brought you back today. According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There is a $1,000 fine. The state is opposing your application for deferred adjudication. The state is recommending community supervision. Just one moment off the record. Mr. Curtis, I'm going to put you in the waiting room until your attorney is ready for you. So just wait there for us, please. All right, we're back on the record. The state is taking in consideration 2022 CR 5350. There's to be restitution of $114. No contact with Christopher Rodriguez. And of course, the length of probation time is outside the plea bargain agreement. Are both parties ready to proceed, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
Are there any witnesses from the state,
No, Your Honor.
defense?
No, yeah. Mr. Duncan.
Are you going to call Mr. Duncan?
Yes, ma'am.
Second? All right, Mr. Duncan, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, so I'm going to need you to keep your voice up so that the court reporter can hear. If you could state your name for the record, please.
Paul Duncan.
All right, defense.
Thank you, Judge. Mr. Duncan, Paul, you're asking the judge to give you deferred adjudication in this case, is that correct?
Yes,
Do you have any prior criminal history?
no, I had a misdemeanor charge back in Arkansas in 91. It was just fine and release, and so doing that.
Other than that misdemeanor in 1991, no prior criminal history?
No.
Are you now and in the recent past undergoing any type of physical or mental health issues?
Yes, I've back in, I guess it was the end of 2017, actually started earlier that year when I got a call from my parents' doctor saying that their care was going to have to be taken over by the state if I wasn't able to step in, and they lived in Arkansas where I was born and raised, and so fortunately with my ex at that point, or with my partner at that point, I was able to take over their care and travel back and forth, taking care of them. And probably about 9 months into that, my mom got terminally ill and wound up passing away in August of that year. And then
What year was that?
I believe it was 2018. 2018.
And that's when you lost your mother?
Yes,
And in the year to year and a half after that, did you suffer other personal losses of people that were close to you?
yes.
What was that?
My father at that point decided he didn't want to be around anymore. I'd had them, or I'd got them set up in a assisted living center there in Arkansas or in Fort Smith, and sold their house for them and got all their affairs in order, and had them in a nice assisted living center there in Fort Smith. And they just, or he especially, was very unhappy with the living situation and being able to be out on his own. And then when my mom passed away, he just didn't want to be around anymore, and ended up falling a couple times, and then in a nursing home where they weren't changing the catheter that he was receiving at the emergency room after he had fallen, and wound up got a call from their original doctor that had called me asking me if I would be able to take charge of their care. And she had seen that he was in the emergency room again, and asked if she could step in and take a look at his case, and he wound up that she ordered a spinal
Well,
tap.
I'm gonna interrupt you at that right now, and I appreciate you explaining these things to the court, but really, if you can just kind of
Okay.
try to listen to the question, just answer it directly instead of
Okay.
too much narrative. And my question was, after your mother passed, did you suffer other losses? And who were those that you lost in the year or year and a half after that?
I lost my father in January. He passed away the Friday before would have been their first anniversary apart. My kid's mother passed away that following January. And then my partner passed away the May after that, and in that same year. And those, that starting with my mother was kind of a big emotional and mental spiral for me, because I was also having a lot of home issues that was causing me some.
And by home issues, what do you mean?
Two relationships that were very mentally and emotionally destructive for me.
Do you have children?
Yes.
And how was your relationship with your children at that time?
It became pretty much non-existent. My kid's mom was very detrimental to my relationship with the kids, and they had issues. They had issues. Of course, they were traumatized very much by her passing as I was, but that brought to light a lot of the past issues that we had tried to work through together and are still working through today.
And so did that lead up until that point, how were you employed?
I was project manager for a construction company, and then also Connie and I owned an insurance agency and a retail shop out in Burnett County.
So were you living a good, stable life, your income
Yeah.
good?
Had a home that was paid for, had three businesses, and then my work as well.
After those losses that you suffered, and what toll did that have on your mental health? Have you been diagnosed with mental health issues since then?
Yes, I've been seeing a counselor and working towards, I've got an appointment on Wednesday with a counselor there at Family Elder Care in Austin to get set up on some of the programs that are available. That they're gonna go through an evaluation of my history and my situation.
Have you been diagnosed with any mental health issues?
Yes,
What are
depression and anxiety have been a big issue from pretty much from the time that my mom passed, and have been on several different drugs trying to, keep that under control on the anxiety side.
So you talked about a spiral. So for the last 3 years, did these issues that you've had with your mental health and personal issues and your losses result in you losing your job?
Yes.
Did they result in you having trouble with relationships in your life?
Yes.
Did they lead to the case that's made the reason we're here today?
Yes.
Is getting yourself involved with that?
Yep.
At this point, are you asking, as part of, even if it's not deferred but regular probation, are you asking the judge to order supervision and support to treat your mental health issues?
Yes. I would very much like that.
And you're currently living in Austin?
Yes.
You also have physical issues, physical
Yes,
health issues?
I have seizures, and as part of those seizures, I have 7 compression fractures in my back that cause me almost constant pain. That's a lot of times I'm moving and rocking back and forth because I have only one of them they caught in time to be able to do a kyphoplasty surgery.
Is that why you missed court last week? Was the
Yes,
seizures?
I had a seizure and also having some digestive issues, which then they found they found that I had some blockage in some of the artery or blood vessels in my abdomen, and are gonna have my doctor look further into that. Also, I go to Vivint Health, which used to be AIDS Services of Austin, because I'm HIV positive, and so all the issues related to that have just kind of compounded into a sore way of issues that keep me on the run. They've been trying to get me.
Okay, you're throwing a lot out there, Paul. You said there's issues with the HIV positive, and what do you mean by that? What kind of issues is that causing you in your life right now?
Well, it has caused me issues as far as being able to be in public a lot of times during the COVID. They try to get us to make sure that we are up on our vaccines and are wearing masks when we're out in just like general public, and then being around other people. I've tried to find work that in my field that's work from home or remote type of work, and that's been successful so far and worked out better in dealing with that.
Are you looking forward to whatever conditions, programs the court will order regarding not only your mental health, but any type of substance use issues that you may have or may have had? Are you willing to and open to abide by any of those conditions?
Yes.
Is there anything else you'd like to talk to the, or mention to the judge?
Just that I want to express that I definitely, once this issue happened back in December, that my life changed dramatically at that point, and it's not been easy, and it's actually been much more difficult, in many ways, especially most of those people in support and core friends that I thought I had have walked away because a lot of them were in relation to the drugs and to that issue was more along the financial side than it was anything for me personally doing the drugs. It was more of a financial thing, trying to soften the blow of losing my job and all the issues that I was having on my home front. So just want to make sure that that's clear, and it's not, I understand and I know that the drug is a problem for anybody and everybody that does it. And I see that, and I see so many times when people sit there and say that it doesn't affect them or doesn't, bother them in that way. And you can clearly see that they're altered by the results of it.
Are you in communication with your children now?
I am starting to get back in communication with them. I've gone for about almost 2.5 years without being able to talk to them on a regular basis, and not necessarily due to the drugs, but due to just our relationship in general and my life in general.
And so you're talking to them now?
Yes.
Where do they live?
In Arkansas,
Is it-
outside of Fort Smith, Arkansas.
Is it your hopes that ultimately you can move up to where they live in Arkansas and be part of their life?
Yes, because my daughter's her health is in really poor condition right now. And she's got 3 daughters and is going through another divorce, and is desperately, needing, since her mom passed away, desperately needing me to be there closer, and I've not been able to because of this. Okay. Feel a lot of guilt for that.
That's what.
Sir, just really briefly, did you have an opportunity to look at the drug lab for this case?
The drug lab,
Yes, sir.
I don't believe so. No.
Okay, would it surprise you that one of the items that was found in regards to this case, it was 253 grams of what tested positive for methamphetamine?
It's probably not.
Okay, and then there is one other item that was tested, or 2 other items that were tested. It was about 75ths of a gram of cocaine. Would that surprise you?
I didn't hear you. How much of a
75, 0.75.
0.75?
3/4 of a gram.
Okay.
Sorry, horrible math. And then finally, would it surprise you that the last item that was measured, it was about 14.5 grams.
Nothing.
Pass witness, Your Honor.
All right, any follow-up questions?
No, Your Honor.
All right, so I have 2 questions for you. One, if you're drug tested today, what are the results going to be? And before you answer, know that you are going to get a drug test today.
No. I do not know what the results would be.
Well, let's start with this. What have you been using?
I stopped using meth, and that's pretty much what I was using, period. As soon as this case happened, I faltered a couple of times over the time, and I was telling Mr. Crum out in the hall that my son has had issues in the past with addiction. And
Okay, so time
Has been
out, because let me just tell you what is happening here. What is happening is I'm asking you a question and you're not answering it.
Okay.
All right, so my question is not about your family. I'm going to get to that in a minute. My question, everyone, you need to make sure your phone is off. That's okay. My question is, you're going to get drug tested today.
Yes.
You said you're unsure what the result's going to be. So my next question to that is, what could you possibly be positive for? That's my question.
No, the only thing that I could be positive for would be meth, and that would be not having done it recently. I think my last spent was about 57 days, I guess.
No, here's the thing. If you use meth 57 days ago, you shouldn't be positive.
No.
So how could you be positive for meth if you used it 57 days ago?
No, I said my last stint or expense without using it was 57 days. And so I had.
So here's the question. When is the last time you used meth? You are going to be drug tested today.
Yes,
The state has agreed to you having probation. So I'm inclined to follow that probation. When I'm asking people about their drug usage, I'm trying to figure out where you are in your sobriety. So what could you be possibly positive for today? You've answered meth. My question for you is, when is the last time you used meth?
Thursday evening.
Now, was that so hard?
No.
All right. So here's the thing. You've got to stop avoiding people's questions, because at some point you're going to have to look in the mirror and be honest with yourself.
Sure.
I did listen to your testimony. I internalized everything I hear. And a lot of what I heard from you is how you need to be on probation, or you need to get this because of other things happening in your life. You need to help your daughter because your daughter has children. You're not a good person to be helping your daughter right now because you're not clean and sober. Do you understand?
Yes.
All right. My next question is, when did you stop having employment?
My last full-time job was with Patriot Directors, and that was August 2019.
All right.
And I was on unemployment for more than 2 years throughout the COVID situation.
So you were using these drugs, I guess, for use and to supplement your income
I was using during that time.
and to supplement your income?
Yes,
All right. And how many grandchildren do you have?
5.
And what are their ages?
They range from 15 down to 2.
So are you currently employed or no?
No.
How are you supporting yourself?
Contract work and friends, working with friends and on jobs that they do.
And are you asking to remain in Bear County, or are you going to go to Travis?
I live in Travis, so I would prefer to be there.
All right, so Mr. Duncan, you had a lot of drugs, and I always tell people, when you're having a bad time in life, you shouldn't be making people's lives miserable, right?
Yes.
So you're selling drugs. Guess what you were doing? You were building your happiness off someone else's misery. And the amount of drugs that are in this case, the court is not going to grant you deferred adjudication. You understand? I'm going to follow your agreement and give you probation. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. There's $1,000 fine that will be probated. Take in consideration 2022 CR 5350. There's $114 restitution to SAPD for laboratory testing. There's to be no contact with Christopher Rodriguez. Transfer to Travis County. There's to be regular reporting to probation by Zoom or in person. We're going to do the UA hotline until further notice. TAP evaluation. We'll follow the recommendations of TAP evaluation. If the TAP evaluation recommends inpatient treatment, then we'll do intensive outpatient treatment. And I think Travis County may have their own drug program. If they have a felony drug court in Travis, see if he can be referred to their felony drug court. There's to be no unsupervised contact with minors. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And as Travis County does it, I'm going to want field visits 2 times per month until further notice. If Travis County does the field visits and within 3 months they see everything is fine, then they can do it as they see appropriate. Probation, is there anything else he needs? Is there anything else you need from me, Mr. Duncan, in order to be successful?
Just the support on the mental health side of things and working with like I said, I've been working with and working towards a plan on that with my counselor and my case manager there at Live and Health.
All right, so we can do a MIC evaluation. That's a specialized caseload, so they'll be able to address the mental health issues. And you're to sign a release of any mental health doctors that you're seeing and your case manager. That'll help probation coordinate things with them, okay? And I'm not going to order, the state is requesting 200 hours community service restitution. I'm not going to order that because I want you to keep up with your mental health issues and keep up with your drug issues, okay?
Thank you.
All right, anything else you need from the court? I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Sir, did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Yeah. Then you have no right
Okay.
to.
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. Mr. Duncan, I'm serious. Everyone goes through life with mental health issues. People have ups and downs with their families. And what you hope for is that people don't take advantage of you. And by doing what you did, you took advantage of other people and you tried to build your happiness off of their misery. And what I mean by that is you are more concerned about your finances and not concerned with the people that you were hurting. All right, you need to think about that. And when you get your drug treatment, all the people that you need to apologize for not being in their lives, not being the great grandfather that you should be, not being the great parent that you should be, you need to apologize to them. You understand? All right, good luck to you, Mr. Duncan.
Thank you, Judge.
You're welcome. All right, who's here on Richard
Judge,
Montes?
I'm here to ask about the approach
Yes.
past this. It's just for in regards to additional
Oh, this?
hours. Yes.
Okay. No, we don't have to be on mute.
Thank you, Judge.
You're welcome. Who's here on Tracy Fitzpatrick?
I am Judge.
Where's Tracy Fitzpatrick?
the jury box, Judge.
All right, come forward, please. All right, what is happening with Mr. Fitzpatrick?
Judge, back on October 24th of 2019, we asked to have him psyched and it was ordered. He was found incompetent in January of 2020. He spent several months awaiting transport because of the active COVID at that time. Finally did get transferred to the state hospital in December of 2021.
All right, so is he currently competent or no?
Yes, he just recently had his competency restored. So I talked to the state and Ms. Hayden said that they need to do, can't remember what she called it, but basically they need to try to contact complainant, I think in the aggravated assault thing.
All
Judge,
right.
I'm unavailable the 11th to the 25th of this month, but I don't know if they can do anything by the end of the week or.
State, do you have any idea?
Just need 30 days.
Okay, the only thing is, state, I know you're asking for 30 days, but what the court has discovered is sometimes when people are in custody, they stop taking their medication and then we're back on the wheel. So,
You taking your meds right now?
so this is what I'm going to do. I'm going to recall it. You're out on the 11th, right?
Yes, Judge. I mean, I could be available by Zoom. That's not.
I
a
know the
problem.
11th is a holiday,
Well, right,
Yeah.
yeah, but starting in, yeah.
but are you able, even though you're going to be gone the week of the 14th, are you able to zoom in?
Absolutely.
All right, so state, let's just see if you can have it by, Norma, can we come back on the 18th? All right, so we're gonna see if you can have everything by the 18th. If you don't, then we'll see where we are at that time. So, Mr. Fitzpatrick, we're gonna bring you back on November 18th. All right, thank you. All right, and Norma, on this one, before I can go forward, I'm gonna need something that says that he is currently competent and he's been declared competent. Did they have that hearing?
Yeah. They sent us the file.
Okay, but no, I need the order like in the file. Because I only have the commitment order. I don't have the order that he's currently competent. So just make sure that gets placed in the file. All right, are parties ready on RC Curtis? Yes.
I asked him, he was close, and he said that he's still in the 226, and I guess she did not really want him to leave. He wants to finish this week.
So
It was set for trial. I think he's pleading a trial case, so I'm sure that's what's going on. You want to go down there and check?
yes, please. Thank you.
Up there to 226.
And Norma, we can have Mr. Fitzpatrick by Zoom as well. That way, if the defense attorney needs to confer, it'll be easy to confer with him by Zoom. Who's here on Crystal Cherry?
Good morning, Judge McCarthy.
All right, and if Miss Cherry can come forward. Good morning.
Good morning.
All right, so where are we on this case?
Judge, I conferred with the state this morning. They need to reach out to the complainant to see if the complainant's open to a possible resolution. And I think that's just the time that the state needs to follow up.
All right, State, how much time do you need to reach out to the complainant on this case?
I spoke with Daniel. Looks like you've been in contact with the complainant, so it shouldn't take too long. It was just setting up a time for us to get in contact with her.
All right, so if we recall this, the week of the 14th.
That should work as far as we're aware. She answers.
Okay. Yes, so we'll come back on November 18th.
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you. I'm loving the pen.
Thank you.
All right, who's here on Julian Reyes? Thank you.
Can I just apprise the court kind of what's going on with
Yes.
that matter? So he's got two cases. Mr. Tochi is hired on the indicted case.
Yes.
And Mr. Tochi, I think, has filed a motion to set bond.
Okay.
I am appointed on his most recent case, which remains unindicted, but there's a bond set on that one.
Okay.
So Mr. Tochi, I believe, is in impact at the moment with Judge Angelini. He and I met up in the hallway and he knows that it's on today.
Okay.
So I just wanted to tell the court what's going on. So I don't really have a dog in the fight today.
Okay, so what we can do is we can reset it because I don't believe he's going to be allowed to leave impact.
That very well may
I mean,
be
these are just predictions for me.
You're right.
I could be wrong.
Generalized.
Yes.
That's fine.
All
So-
right. So,
He had asked me for it to be set today, but it's been reset so many times already.
Yeah, he was pretty insistent about it.
And so, because he just wants a bond set.
Correct.
Other case, but we were waiting on Melissa to come because I think she was in trial.
Yes.
And so it was kind of trying to get both attorneys here at the same time.
all right, so this is what I'm going to do. If he shows up, because the court is recessing at noon.
Okay.
If he shows up, we're here. If not, it's going to have to be reset.
Does she need to be here?
Would you like to be present?
I don't need to be present because
You know what? Your input is always fabulous, though.
and as much as I appreciate that, Judge, I think he just wants a bond set on his indicted case.
All right, Norma, if he's doesn't show by noon, then this is going to be reset for the 18th.
Okay.
All right, thank you. Have a
Judge.
great rest of your day.
Thank you so much.
All right, are we ready on Mr. Curtis?
Gonna argue here or tables?
Oh, whatever is most convenient for all parties. I think it's what, 10 people on this now? So I don't know.
If everybody wants to keep working back here, I don't mind arguing.
Okay.
I'm gonna stand right there.
Okay.
I didn't move this for nothing.
All right, so before we go on the record, because I'm sure people have a lot to say. So please speak clearly so the court reporter can hear you. And let's not talk super fast.
Are you looking at me?
No, I'm just looking out in the audience in general. Yes, every last one of you. Okay, so parties, you will have a chance to do your argument. The court will listen to your argument. Mr. Curtis is by Zoom. The court is calling 2019 CR 10230, State of Texas versus RC Curtis. Could I have parties announced for the record for the state?
Nathan Maury and Daryl Harris for the state.
Defense?
Dana Jones, Charles Funk, and Kelly.
All right. And by Zoom is Mr. RC Curtis. Both parties had agreed that it was okay for him to appear by Zoom. Does anybody have any objection for the record for Mr. Curtis appearing by Zoom? State?
No, Your Honor.
Defense?
No, Your Honor.
All right, so defense, it's your motion. You may begin.
Thank you, Your Honor. I wanted to start with kind of a history of the Oregon versus Kennedy standard and why Mr. Maury in his briefing really cited to ex parte Wheeler and why that's not
Oh,
really.
and just 1 second. If everybody can remain seated because it's easier for Brenna to hear, easy for me to hear because the microphones will pick you up better. I don't take that as a sign of disrespect. I know everyone has to remember to do that because we were always taught to stand, but you don't have to stand here.
Okay.
All right.
And so in Mr. Maury's briefing, the state's briefing on this pretrial writ, they talk about a lot about ex parte Wheeler. So I want to kind of go over the history for the court on some of these cases that we're applying to the facts of this particular case. So in Oregon versus Kennedy, where that came about was during mid-trial, one of the prosecutors asked an expert witness, had he ever done business with the defendant? And the expert said no. And when he said that, he's like, why? Is it because he's a crook? And in that particular case, it was a theft of a Persian rug was the facts of that case. That mid-trial one question litigated all the way up to the US Supreme Court. And that one question, what they were reviewing in that was, did the prosecutor intentionally ask that question to goad the state or the defense into a mistrial? So that's the facts of Oregon versus Kennedy. In 2006, the Court of Criminal Appeals issued the Ex parte Wheeler opinion. Wheeler, which is highly cited by the state in its briefing, again, came down to one question. The prosecutor, an expert witness for the defense, was on the stand, and the prosecutor asked the expert, did you know that her insurance, the defendant's insurance, already found her liable for the accident? And that was an improper question that, again, gets a mistrial granted and litigated all the way up to the Court of Criminal Appeals. In Wheeler, or I should go back to Oregon versus Kennedy, Justice Stevens, in his concurring opinion, talked about how difficult it's going to be to get into the mind and the intent of a prosecutor in those circumstances. And that's what the states across all of the United States that are following Oregon versus Kennedy are grappling with, is how does a judge review what's in the mind of a prosecutor during trial? So Wheeler, based on that one question mid-trial, tried to articulate certain questions to help the court, guide the court on getting into the mind of a prosecutor when he asks a question like that. But the problem with applying Wheeler to our case is Wheeler came out in 2006, and then Ex parte Lewis came out in January of 2007. Ex parte Lewis overturned Bowder. Bowder was a case that it was a little bit more favorable to the defense when applying double jeopardy. So it overrules Bowder, but 2 months later, they issued their opinion in Ex parte Masonheimer in March 21st of 2017. Masonheimer does not once reference to Wheeler at all. And the facts of Masonheimer are directly on point with the facts of our case. So probably the reason that I'm guessing that the Court of Criminal Appeals wouldn't reference Wheeler and that standard of questions is because it doesn't really apply when we have pretrial Brady or not disclosing Brady material pre-trial like they had in Masonheimer.
All right, just one moment. Could you place this on mute and stop again? Could I have attorney's approach? All right, defense, you may continue.
So I also want to point out Ex parte Lewis overturning Bowder, that was a 5-4 split decision from the Court of Criminal Appeals. Masonheimer coming out 2 months later about Brady violations was a 6-3 opinion. So within 2 months, a couple justices joined the other side about reviewing cases or upholding double jeopardy, barring retrial when Brady is disclosed late. So looking at the facts of Masonheimer, essentially what happened, and it's briefed in both the pretrial writ, and I again referenced it in the bench brief that was filed last week. Essentially, a trial happens, a mistrial was granted in that particular case, and then they come back and the Masonheimer, he pleads, but they're leaving it open to the court on deciding whether or not the facts of the case warranted self-defense or whatnot, and sentencing as well. So in Masonheimer, they then mid-trial in that trial disclose more Brady material, and the court grants a mistrial and then says double jeopardy is barring this another trial of Masonheimer because of all of the late disclosures of Brady. So Masonheimer also came out with the Wheeler questions talking about, did this state intentionally do this to goad? The questions of Wheeler are like, did they do this because the case was going badly for them at the time that they disclosed or they asked the improper question or committed whatever the misconduct is? And the reason in Masonheimer, they said, okay, well, an additional bar, we're going to add an additional bar to retrying somebody when they've intentionally withheld evidence pre-trial with the intent of avoiding an acquittal. And that's what we have. That's what needs to be applied to the facts of this case. Looking at the facts and the testimony from the hearing that we had on this over the span of 2 days, we know that at least one person from the prosecution team, at least one, knew about the Pena and the Joneses interviews. And we know that at least one knew because it was Detective Hines. He's a member of the prosecution team. He's the one that conducted those interviews in the summer of 2016. But I find it interesting, all of the prosecutors that got up on the stand that had any involvement in this case, and they all seem to point the finger at somebody else. Elena Altis, she was only on this case for a couple months, it sounded like, but the evidence that was turned over had her name on it. The Pena interview had her name, attention to Elena. She says she never got it. And then the case gets passed off to Scott Simpson. He's on it for a little bit. But then Mr. Harris, ADA Harris, he was on it for over 4 years before this case went to trial. But Detective Hines, being a member of the prosecution team, we know that he had already filed the case against R.C. Curtis, his prosecution guide, and they had already indicted R.C. Curtis. And then after that indictment, he interviews Pena and Jones. After that indictment, and he learns the information contained in the Pena and Jones interviews. But yet he doesn't make one notation in his RMS notes. He doesn't make one additional police report saying that he interviewed these particular people. The testimony from, I want to say that it was Mr. Harris, testified that any competent person would have followed up on the information contained in those interviews. Hines did not follow up. He's the lead detective on this case, and he didn't even follow up on the information that he learned in those interviews. He doesn't make any notation of it. He goes over to the DA's office and he drops the Pena. We know that Pena's DVD was dropped off. Sorry, Jones's DVD. I'm sorry, Jones's DVD was dropped off, but yet he doesn't even log it in their logbook. There's no record besides a file stamp on it saying that it was dropped off. When it comes to Pena's interview, we have no idea when it was turned over or how it was turned over, when the DA's office became aware of the Pena interview and how it got into their box. So again, Hines is the one that absolutely knows this information. Now, Hines says he met with Mr. Harris and discussed these interviews pre-trial, the information contained in these interviews pre-trial. Mr. Harris and Mr. Spear testify that he's mistaken. Their lead detective is mistaken on how he handled favorable evidence that was important for the defense, absolutely important for the defense to have. Mr. Hines, Detective Hines, he also testified that, the interviews came after I had already turned over my prosecution guide, but then I questioned him about, well, you filed supplemental prosecution guides, didn't you? And he says, yes, he did. But again, he never made any notation of this. It's obvious that he took steps to not disclose this information. It would have, he put information in his prosecution guides about emails he received that were really meaningless to the case, or phone calls that he had that were really meaningless to the case. But two people that everyone agreed that a competent person would have followed up on, he completely avoids putting that in any notation in any of his records whatsoever. Now he's testifying, he says, well, I did tell the state that. That's a good way, to say he turned all of this stuff over and that he disclosed it and he addressed it with the state, but the state's saying, no, he never did bring that up with us. So looking at this evidence was absolutely Brady. And I don't know if the court's aware, we just found out last week that Mr. Jones, Antonio Jones, who was the subject of this interview, one of the interviews, he is in a prison up in Indiana. He's in prison up in Indiana for murdering Roberto Cisneros. Roberto Cisneros is the guy who Antonio's mom punches on the shoulder and said, y'all filmed that shit. That's what was contained on that interview. So we have a dead witness and another person, or a dead person that we believe is a party to this, and another individual murdering him and serving him nearly 58 years in a prison up in Indiana. But none of this stuff was ever followed up on by Detective Hines, and it was never disclosed to the defense to make use with it in his trial. So if we applying what the court found in Masonheimer to this case, there is no doubt that somebody from the prosecution team knew about this evidence and took steps to not disclose it to the defense. It only was disclosed mid-trial when Your Honor told the state, because other evidence was coming out that hadn't been disclosed. And you told them to go and make sure that they have turned over everything. And then the next day, they go and they find these particular interviews that had never been disclosed, and then the mistrial gets granted. They didn't turn it over because, they felt the trial was going poorly or whatever the case may be. They turned it over because they were ordered to do it. But we do know that either they were aware of it, the prosecutors, or somebody from the prosecution team was absolutely aware of it and had never disclosed it. And the only reason for that and not following up on it is because it doesn't fit the theory of their case. It doesn't fit with what they were presenting as their theory. And the only reason to not turn something over that is favorable to the defense but doesn't match the state's theory of the case is to intentionally withhold it so that the jury will never hear about it and maybe find the person that they want to prosecute not guilty. So for that, Your Honor, I think that applying the questions that Mr. Morey has laid out in Wheeler, even if Wheeler does apply, all of those questions could still be answered against the state and in favor of the defense. But it's Wheeler again was a question asked mid-trial, just like in Oregon versus Kennedy. And Masonheimer added that additional bar of intentionally withholding evidence to avoid an acquittal. You can't apply Wheeler questions to the facts of that case. I also cited to a case out of Nevada because others, like I said, other states have grappled with this issue. And Nevada, and again, obviously the Nevada court isn't binding, but I think a lot of their logic and reasoning is really sound when it comes to Brady violations and mid-trial mistrials. But the Nevada court also found it under facts and circumstances like we have here, like they had in Masonheimer, that double jeopardy would apply and the defendant cannot be retried.
All right. And for the record, the court does have the state's bench brief and defense. I had given both parties a chance to file any extra briefs that they wanted to file. Did you file one outside of the application?
Yes, a bench brief was filed on Thursday on the day that they were due about 4:45, and it was accepted on Friday morning.
All right, so I'm going to have the clerks to pull that for me because it's not in the file.
I have a copy for Your Honor if you would
Yes,
like.
please. Thank you. You're welcome. All right, state.
Your Honor. I want to reiterate what I said a year ago, and I believe what Mr. Harris said over a year ago, and that is that, and I believe these were Daryl's words, that he did take responsibility for this. So everything I say is not an attempt to excuse the failure to disclose these discs today, but it is an attempt to explain them and explain them under the proper legal standard and to show why the critical issue of intent is not supported by the evidence in this case. First, every single ADA who was called to the witness stand in this case told you directly that they had no intent to withhold evidence in this case, whether it be to go to mistrial or to avoid an acquittal. They also all said, and this is consistent, I think, with practice in all the administrations I've worked for here, that they would have allowed for a physical inspection of the file box had one been requested. There was also testimony from UDN that Daryl was surprised to find out that we had the 2 additional discs in our box. That supports the conclusion that Daryl nor anyone else in the prosecution team or anyone else in the DA's office was aware that we had the discs. Hines did deliver the discs after he forwarded the primary prosecution guide, and he did so without supplements. So the supplements are obviously crucial. They're sort of our roadmap, And if there's no supplements, then that would lead one to believe there would not be a disc to accompany the supplement in the box. There were 2 other discs that were forwarded afterwards for Hyman Reed and Scott Perez. They did come with prosecution guide supplements. I'll note that Perez actually said he watched the video, so this is not a matter that we were sitting on top of. The video, its existence, the person who actually saw it, that was disclosed prior to trial. These interviews, when looking at the entirety of the case, simply don't amount to material evidence for the defense. I'll agree they should have been disclosed because I agree they should have the opportunity to establish that materiality. And perhaps they can by the time the second trial comes around. But the record as it stands today, though, they have not shown that these discs are material to the defense. This case is one that involves DNA evidence that was found underneath the victim's fingernails and Mr. Curtis's semen, which was extracted from her mouth and then matched to a known sample of DNA that was collected from him. The evidence that Mr. Harris was in the process of introducing, it would continue to introduce, showed that the defendant in this case had possession of the victim's bank card in the time period shortly after her death. Contrary to what the defense just argued, there is nothing contradictory, assuming there is another person involved and assuming this was videotaped, none of that contradicts the state's evidence. And that's their biggest problem here, is that it does not remove Mr. Curtis's DNA from the victim's body. It does not remove the credit cards from his fingers at the time he's trying to use them in an ATM on Evener Road. So was there another person there? Perhaps. Will that ever be, will that lead ever be conclusively dealt with? I don't know. We are continuing to provide them with evidence. If we are going to get police reports from Indianapolis and we will turn those over. If they want us to find something for them within reason, we'll attempt to find it. But so far, none of that negates the strength of the case that the state was in the process of proving at the time of the trial. And that gets to the final problem with intent, is there was no juice in this squeeze for the prosecution to withhold this. There was no reason for us to compromise a case built on solid DNA and solid surveillance footage with a defendant who had a known relationship to the victim, because there was some other lead that may or may not have gone somewhere. Especially one that was already disclosed, in the sense that the original prosecution guide had always referred to the existence of this video, and Detective Hines had even left it in the prosecution guide as an open lead. Open lead. So let's talk about the law and what that has to do with this. I agree with what Dana is saying about Masonheimer versus Kennedy to an extent. In the Masonheimer case, the Court of Criminal Appeals said when the state intentionally engages in misconduct with the intent to avoid an acquittal, that the trial is barred. The way they came to that reason is they looked at Oregon versus Kennedy, they looked at the cases it cited, and they simply said that that type of conduct, an intentional misconduct with intent to avoid an acquittal, was the same kind of harm that intentionally goading a mistrial. So I don't think they create necessarily a completely new standard. They just say this is the other side. This is the flip side to that coin. It's basically the same standard. And what's the same about it is intent. That's what's crucial here. You have to show intent. You have to show that Daryl or Stevens or Elena or anyone else, Scott, knew that those discs were there and that they sat on them with an intent to avoid an acquittal. And the evidence before the court does not amount to such intent. Defense has provided cases from New Mexico and Nevada, WRIT and Thomas, I believe. On the WRIT case on page 795 and again on 803, it's clear that the New Mexico Supreme Court is deciding a different standard under the New Mexico Constitution. It is simply inapplicable here in Texas. Again, in Thomas. On page 469. Yeah, page 469, the Nevada court makes clear that they are deciding this pursuant to Nevada law. The Court of Criminal Appeals, their version of these two cases is different. It's Masonheimer, and all it does is it. We could debate academically how Masonheimer is different from Kennedy, but at the end of the day, they simply said it's the same harm and it's the same sort of intent involved. You have to have intentional misconduct. The record here does not show that. I will add one other thing. The defense's argument here implies, I guess, that it sort of tries to graft a case called Kyles v. Whitley onto the double jeopardy standard. In Kyles v. Whitley, the Supreme Court said that Brady applies to not only the prosecutor's office, but the prosecution team. That's those who are working on behalf of the prosecutor, police officers, etc. I'm not aware of any case where the Kennedy or Masonheimer standard was extended to a police officer's conduct, period. Whether it was intentional, reckless, knowing, I'm not aware of any such case. If they can provide one, I'll be happy. I will say in this case here, I don't believe, even if you did extend the reasoning of Masonheimer or Kennedy to Detective Hines, they still have not shown the necessary intent. If you look at this situation, Detective Hines had a case where a defendant, you had DNA, you had circumstantial evidence of the victim's credit cards tied to the defendant. And I think he believed that this video was a rabbit hole that he followed it to a certain extent and then he abandoned it. Not because he wanted to withhold this, but because he didn't think it was going to get anywhere. Now, why were they entitled to it? Because they have the opportunity to independently decide whether that rabbit hole goes somewhere. That's why they have it now. I encourage them to try to develop that as much as they can, but ultimately the issue here needs to be decided by a second jury. Because there's no intent on anyone's behalf to hide this evidence from the defendant, either to go to mistrial or to avoid an acquittal.
Rebuttal, Your Honor.
Yes.
It's one, he's asking the defense now to go and develop a theory that Detective Hines should have developed, and everybody agreed that testified under oath, agreed he should have, a competent adult would have followed up on. The problem now that why Mr. Curtis cannot get a fair trial because of all of this violation is because the witnesses are dead. They murdered each other. Witnesses, Roberto Cisneros gets punched in the arm and somebody says, y'all film that shit. He's dead because Antonio Jones, somebody, an interview that they didn't turn over, murdered him. We just found that out last week and he's been in prison for that since 2018. But we didn't even know about Roberto Cisneros's getting punched in the arm or any of that kind of stuff or the Jones interview because they never followed up on it. And then they don't turn it over until they're ordered by this court mid-trial. And, you know, I hate to be juvenile about this, but there's a saying that when you point the finger at somebody else, you always have three fingers pointing back at yourself. If you ask a child about, you know, if they put their hand in the cookie jar and or something goes wrong and they want to point the finger at their sibling, that's what's going on here. The DAs, every single person that got up on the stand said, well, I think Daryl even said, well, I just assumed that my predecessors would have applied the system correctly and turned over everything. Elena says, well, Monty was kind of on the case at a point in time. It was just everybody pointing the finger at somebody else. Detective Hines had the information and he gets up on the stand and he wants to say, I did talk to them about it. And they all say he's mistaken about it. Where the real culpability lies, that's the part that we may never find out. But what I do know is that if somebody intentionally does not follow up on evidence, does not put a single notation in a police report, doesn't do anything to look for evidence on a lead that they have, and he says that, well, maybe he did look for it and it didn't go anywhere, and that's that now they can go ahead and do it. We can't go ahead and do it because, again, witnesses are dead, people aren't around anymore to be able to do that. For 5 years, 5.5 years, they sat on this evidence and then try to go to trial where they're trying to put somebody away for the rest of their life in prison without the chance of getting parole. for the rest of their life, and they want to point the finger and say, well, they can go get it now after they sat on it for 5.5 years. We can't do that now. But I cited the New Mexico case, not because of the reasoning that they were, or the rules that they were making up. I cited it because they made a really valid point. The purpose of double jeopardy is not to punish bad prosecutors for not doing their job, is to protect the rights of a defendant. R.C. Curtis cannot get a fair trial now because they sat on it. Their detective sat on it in a box in their office for 4 years. They had evidence that they sat on and never turned over. Whether they just didn't look for it or they didn't review it, that's their job. And they now want to point the finger and tell us to go get evidence and follow up on leads. He cannot get a fair trial here because witnesses are dead. Witnesses are missing. It's just not going to happen because of their responsibility, and they didn't do their job adequately.
All right,
With that.
so it is the defense's motion, but if states you wish to respond, I'll give you one last chance to respond, and then I will give defense final argument.
I just have one very brief comment I would like to make. We have stipulated that Roberto Cisneros is in fact deceased. We are looking into the circumstances around that. We do believe at this point that it was probably due to Antonio Jones, and that Antonio Jones is serving a prison sentence. We've not gotten the official documents, but we will turn them over once they're in hand.
Your Honor, that's not true. I supplied them, Antonio Jones was convicted
Okay,
of
all right,
murder.
just 1 second. So everyone, I understand that sometimes tempers can get a little bit high. Sometimes we take it here. In this court, I'd like to always keep it here and everybody treats everybody with respect. So I'm giving each one a chance for you all to make your record. Defense, you will get last argument. So I will make sure that you have last argument because it's your motion. State.
This is from my perspective, and if they want to fill it in, I'll certainly happy. The only reason we know Roberto Cisneros is dead is because prior to this case going to its first hearing, there was a hearing where we came in and we ended up setting it back for 2 days. Then I saw they had an investigator. And I told Daryl, let's look into these witnesses. Maybe they've got something, that they're going to present. Let's get ahead of it. And lo and behold, a couple days later, we get word that Roberto Cisneros is dead. Now, in the meantime, they called their investigator to the stand, and he said he was looking up Robert. It was a totally different thing. So I don't think they had any intent to find Roberto Cisneros. Roberto Cisneros' date of birth and name was in the original prosecution time. While the specifics of what was her name? Christina Guerrero hitting him in the arm and saying, "Y'all film that," I agree those were not. And I agree that should have been disclosed, and we did disclose it. But Roberto Cisneros and his general relationship to this case was available. And once they got that in hand in January or November, they didn't even look for the right Roberto Cisneros, best I could tell. They were looking for someone totally different. And they did it in a manner that showed that I don't think they wanted to find him. And now that he's dead, now, of course, he's the most important thing. Now, I understand that there are other constitutional rights that deal with prejudice to the defense, and maybe we're going to have to deal with one of those. But this one here focuses on the prosecution's intent. That's what the law says. It doesn't focus on prejudice to the defense, maybe a speedy trial claim or some other due process claim. They can file a motion on that. The court can hear briefing, the court can hear evidence and argument. And maybe we'll have to deal with who Roberto Cisneros was, what he would have testified, whether he would have testified, and whatnot. But that's not an issue today. And furthermore, we didn't know about Roberto Cisneros' status as being dead, or Antonio Jones' status as being convicted until in the last week or two. And we disclosed those facts to the defense. That's all I have to say.
All right, defense.
Briefly, on the point that he made that we don't know if Antonio Jones really was the one that killed him, we're looking into that. I supplied them an appellate opinion affirming his conviction for the murder of Robert Cisneros. He had a bench trial in Indiana. His only defense was, I acted in self-defense, and nobody believed that the judge convicted him and sentenced him to 58 years. I supplied that to the state. They have that information to say that they're looking into circumstances and all of that. It's simply not true. Aside, it's interesting that Mr. Morey seemed to say that maybe some constitutional rights being violated, but that's what we don't need to deal with that or address that today. And then tries to argue that the intent of the defense was not to find these favorable witnesses or anything like that when we're arguing intent of the prosecutor, and there's absolutely no evidence that there was no intent to find people. We didn't start looking for these particular witnesses until after the trial, and we were looking for particular people based on the disclosure of Brady material and understanding what their involvement was in this case. There's nothing indicating that in the materials that were supplied pre-trial that Cisneros was there present murdering somebody. It came from interviews that were not turned over that we learned about that. But he died in 2018 at the hands of Antonio Jones, and we will never be able to ask him or put him on a stand, raise his right hand, and either plead the fifth or answer questions about his involvement in this particular case.
All right. All right, everyone. This is what the court is going to do. Both parties have had a chance to hear each other's argument. I know both parties filed a brief. If anyone would like to supplement that, you're more than welcome to supplement based upon the arguments that have occurred in court today. But that is going to be due by November 18th. It will not be pushed past November 18th for any supplemental briefs that anyone wishes to file. And that's going to be November 18th. And I am going to say by 3 p.m. And I know we file things electronically, and you're more than welcome to file that electronically, please do. But as you know, as you can tell, there's some briefs that I get because it's been filed electronically and it's working on its way through the system. So while you file that electronically, if you will provide a copy to the court, you can send it to my email. I know both parties have the court's email. And when you send it to the court's email, if that's the way you're going to do it, make sure you include all parties to this case in that. And then the court will have a decision for you in writing on December 19th. So does everyone understand the court's deadlines?
Yes, Your Honor.
All right. Is there anything else from either side before we close the hearing?
Not from the state.
Okay. All right. And Mr. Curtis can appear by Zoom on that date as well. So there's no hearing on the November 18th. It's just that on November 18th by 3 p.m. If anybody wants to do a supplemental, it needs to be filed by that time. And then the court will give you my ruling on December 19th.
In person.
In person.
Okay.
All right. Thank you.
Thank you, Your Honor.
All right. Thank you. All right, Mr. Curtis, I'm going to excuse you. I believe your attorneys will probably be calling you.
Okay. Thank you.
You're welcome. So this will be coming back on the, yes.
MASONHE. It's one word. I. And
All right, who's here on Manuel Sandoval who wants to approach?
BAUD.
Good morning.
BA.
Sandoval had a violation report here this morning.
Yes.
And then Dana spelled it right. I think there was one. It might, but I might have been reading some.
All right, so on these cases,
No worries.
I set hearings so that we can figure out what's going on with the violation report, but because this is a violent offense, I'm going to issue a judge's warrant. All right. All right, could I have parties approach? It's family violence. It's a violation report. All right, the court is going to call State of Texas versus Manuel Sandoval, case number 681916. Could I have parties announced for the record for the state?
Captain Pollard for the state.
David McLean from the defense.
All right, this hearing was scheduled at 9 a.m. It's now 11:10 a.m. The defendant has not been present in the courtroom. Deputy, could you call in the hallway?
Yes, I did, Your Honor.
And was there a Manuel Sandoval in the hallway?
No, Your Honor.
All right. The violation report is that the defendant has not made any contact whatsoever with pretrial officers. And this is an assault family second offense. Defense, have you had any contact with your client?
I have not.
Have you attempted the bondsman? I believe this may be a surety bond and not a PR bond.
I called the information that was in the Bexar County system, and I have not gotten any response back. I've sent letters to the address that was provided when I was appointed, and I've tried the phone number as well. I've not had any contact response.
All right, state.
That's her bond for the check.
All right, what the court will do, the court will issue a judge's warrant so that people will know not to place a bond on this case, that it'll come back to the court. I'm going to issue a judge's warrant and remand your client without bond. If your client makes an appearance, in the court will reconsider. Thanks for coming in.
Thank you, Judge. Appreciate you.
All right, thank you. Have a good one.
You too.
All right, who's here on Caleb Coleman? Yes. All right, Mr. Coleman. The court, oh, you know, I just switched sides. Thank you. All right, Mr. Coleman, you're on bond for a case.
Yes, ma'am.
And it says that you're making unauthorized stops. So why are you making unauthorized stops?
Unauthorized stops.
Yes, because you're on GPS. So I have a violation report for me, and it says that you were making stops at Henderson Pass
Yes, ma'am.
on October 9th,
Yes, ma'am.
2:03 p.m. to 2:21 p.m., then 2:36 p.m. to 2:51 p.m., then 3:18 p.m. to 3:19 p.m., 3:30 p.m. to 3:33 p.m., 3:36 p.m. to 4:51 p.m., 5:06 p.m. to 5:11 p.m., and it says you returned home at 5:39 p.m. So why? It says here, you admitted to attending a football event.
Yes, ma'am.
So why are you making unauthorized stops?
Well, Your Honor, I had the opportunity presented to me to go and try out for pro football team.
Mhm.
Before all this was going on in this case, all my stuff was adding up. I had went out there, I had tried to, of course, talk to the GPS and pretrial people. I had totally forgot due to the case. And so leading up to that weekend, I tried to reach out, but of course, I said the judge was not in on the weekend. And I do apologize for taking that leap of faith, but I tried to test myself to get an opportunity at another job just to get out and get better.
All you had to do was call your attorney. Now, so this occurred on October 9th.
No.
I mean, was this a surprise that this was occurring on October 9th?
No, ma'am, I had got the pro invitation, via email, I had it on my phone. I just didn't, like I said, I was not aware. I was just moving too fast trying to figure out stuff that's going on. I gotta get off this.
Well, here's the thing. You got to make plans. You got to communicate. So you know what's happening on October 9th, which is a Sunday. You should have called your attorney well before then and said, hey, I have this opportunity on October 9th. I consider myself a reasonable person. I think, although I'm not going to put this on them, I don't know how they would have decided. But if the state had any objections to you trying out, we would have had a hearing And then I would have made a decision on it. I'm all for people improving themselves and getting employment. But you're gonna have to start communicating. Otherwise, you know what's gonna end up happening potentially? No, I mean, you'll be brought over from the Bear County Jail. You'll be dressed in either orange or red or whatever classification they present you to, okay? So you've got to, if you want to make stops or do something, all you have to do is have your attorney call pretrial services. All you have to do is talk to pretrial services. And if there's an issue with pretrial services and they won't let you do something, then your attorney will confer with the state. And if the state is not in agreement to it, that's why I'm here. I'm here to make a decision. Okay?
Yes, ma'am.
Judge, I want full disclosure, he did contact me, but he contacted me on a Saturday, right before the event.
You can't do that.
Yeah, that's what's my fault because I was just, I was too static in the head, like I was paying attention to everything, focus on certain things every day, like day by day.
Okay. So is he on full GPS or partial? All right.
I'm able to do, my job that I have is Uber, and that's something I'll be able to do, but everything's coming back on my jobs, that's why I tried out, it was coming back as my case, and they kept trying to like, let me go or, and stuff like that, so.
All right, state with Mr. Coleman.
Yes, Judge.
All right, it appears that he's trying to better himself with different jobs. He is allowed to do Uber, is that correct? So he's allowed to do Uber. So do you all want him to just be on tracking with specific locations he can't go to? Or you still want him just with Uber? Because Uber goes everywhere, I'm assuming. When somebody calls him and if you all in agreement to Uber, I don't understand.
Yeah, I don't understand either, Judge, but Marcus is handling this case. If I could just call him real quick and see,
Yes.
he knows the facts.
All right. So just have a seat and we'll come back to you. We're going to see what to do with this GPS. Thank you. Everyone, the court is recessing at 12. Brenda, you know, whenever I say that, then attorneys start moving. They're like, oh, we're ready. Brenda, do you know, is it still raining outside? Yeah,
Yeah, that's fine.
I'm just like, okay. You know, even though we're inside and we don't have any windows, which I don't understand why we don't have windows, it feels like it's raining outside.
And it always feels like late at night.
It does. Let me ask you this, why can't we have lights in here like they have in Vegas? You know, when you're in Vegas and inside, it always appears like it's in the daytime. They did something special with their lights. Do you think they will give that to us?
I don't think so, Judge.
No, because we can't even get AC. So. All right, Jasmine Hardaway.
Your Honor, are there two cases on her? Or
Yes.
one?
I think there may be, was there one that's, yeah, they're both set today.
There was one that's just recently indicted.
Yes. All right. So with regards to that, do you have all the discovery on that case?
Not the second case, no, Your Honor. And I don't have a plea bargain on that one offer either on the second case.
All
The
right.
First case that's the subject of this potential trial setting, I guess sometime in December, is that correct?
Just one moment. Let me, because I'm sure if the other case is going to trial, I don't know if the state is going to be seeking to use this in some type of way. So I'll need to make sure you have all your discovery on that. So who's the prosecutor on Jasmine Hardaway?
That would be Mr. Mark Sanders.
All right, so she has a new case. So I don't know if you know if there are videos involved in this. It's an assault On a security officer?
I can check, Judge. I can log in and check if there's anything up there and then get you a discovery acknowledgement of what's on there.
And Judge, so I've been reviewing the co-defendant's case. I don't believe that there's any video associated specifically with the assault police officer. There's body cam and things like that, if that's what you're talking about, but
Yes.
there's no direct security video. of the-
Okay, so the new case that has a co-defendant?
Yes.
All right, so what we'll do is we'll recall this on the day with the code. Who is the co-defendant? Is it set today?
I don't know. Your Honor.
I'm sorry? Yeah,
For Wednesday, Your Honor.
I'm sorry, who?
For Wednesday, it was set for Wednesday.
Oh, it was set for Wednesday, this Wednesday?
That was what the defendant kind of,
Norma, can you see, there's I guess a co-defendant in 2022 CR 7550. I think it will be A. Can you see when that is set?
Yes, ma'am.
It's set this Wednesday? All right. Well, I won't have you come back on Wednesday. No, you don't have to come back on Wednesday. All right, this is what we'll do. Ms. Ferguson, can I have a 30-day reset on Ms. Hardaway's case for discovery on the 2022? We're going to keep all these cases together. And when the co-defendant comes on Wednesday, if they don't have their discovery, we'll set them on the same day.
Are we gonna have a trial setting of the manslaughter case?
Yes, that will come up as soon as you get your discovery on this case. All right, December 15th.
That will be the manslaughter case.
No, that's for this case for discovery. The
Well,
manslaughter.
for both cases.
Yes, the manslaughter case will be on the same day.
All right.
All right, so Ms. Ferguson will give you a setting for that. And the December 15th date is to make sure that you have all the discovery on this new case, and then I will give you your trial setting.
So it's not a trial setting of the manslaughter.
No, it's for discovery on the new case.
All right.
Because I'm assuming if it goes to trial, if Ms. Hardaway were found guilty, that the state may be seeking to use this. And if that's the case, I want to make sure
They've
that you have
given,
information.
given no indication of that.
All right, well, we'll find out.
Suppose we'll find out.
Okay, all right, so December 15th. And Norma, just put that as discovery, and that's discovery on the new case. And then I'll give you a trial setting after that. All right, thank you.
Take a seat.
That's fine. I thought this has already been signed. Hello, it's always great seeing you. How are you? I'm doing fine. It's a beautiful day. LSU won.
LSU won. And they shot up in the polls.
Yes.
And I O'Shaughnessy discovery.
But you know what? We can't go to sleep because we have Arkansas. Arkansas tends to surprise people sometimes. We can't let
In
people
what
destroy
sport?
dreams.
Football,
Yeah, I mean.
they lost to Liberty.
Well, you know, give me liberty or give me death. Isn't that what they say?
Liberty. Here.
Well, maybe Liberty ate their Cheerios that day. You know that they say Cheerios are heart healthy.
Only one.
Which one? One that
Oh,
I wrote in.
McConnell, on the Demon Third Mothballs. Oh, you might.
Yes. All right, thank you. And if you could make sure you forward that to Barbara and Julie. All right, thank you.
Do you want me just to run?
Yeah, rough is fine.
Well, I have a, that's the work I wanted to talk about. We're getting close, yeah, we'll go live, I think. And I was wondering how you judge Phil about letting me allow to handle that those in court appointments from. I'll log in, you need something, something comes up and you need something.
Judge,
We haven't done it with
Yes.
anybody yet,
on, common plea,
but I'm learning a
the
lot.
prosecutor said that he would approve whatever job he has, they just need
A lot of people
for us to
don't know
email
this.
them.
Okay.
And so we'll do that. and then-
So he's already on, but he's already approved for, is he not on full? Or is he not on partial?
From my understanding, it sounds like he's on full.
Okay.
And then Marcus just said with proof of documentation, he would approve him to go to, his football stuff and everything.
Okay.
He has another football trial in December, so.
All right, Mr. Coleman, can you come forward?
Tomorrow. I know how to use.
And if everyone could whisper, please.
Right here, like.
I know, that's fine.
So my understanding, you have another football.
Yes, ma'am, sometime in December.
What position are you playing?
They got me a receiver and free safety. Yes, ma'am. My name is on the pillars, my name is on the stadiums out here. Stuff like that.
You don't have butterfingers, do you?
Hey, ma'am, you can listen, you can Google me.
Oh, yeah. So your hands are like Velcro. If a ball gets thrown at you, you catching it?
Like you throw a pen right now, I've got it.
Okay, see, I was about to do it. All right, so what I'll do is, what date is your football schedule?
I honestly have to go back and look myself, but yes, ma'am, I know that they do have it on December, probably like 17th, I will say, but I will reiterate that.
All right, so you need to get it to your attorney before the weekend. Brenda, this is what people always had a hard time understanding. When I was a prosecuting defense attorney, it's like, do you not want your attorney to rest? Must your attorney work on Saturday and Sunday too? Like everybody wants a break. Do you want to work on Saturday and Sunday?
No, Judge.
Yeah, nobody wants to work. So that's why you have to let them know before Saturday and Sunday. And that doesn't mean Friday at 5 p.m. Which, yeah, no, don't do that. So, all right, we'll do partial GPS. Defendant allowed to work upon proof of employment. And defendant is allowed to attend all football camps or workouts.
Does that approve like workouts too?
Uh-huh. But here's the thing about that. I'm approving that, but you're going to still have to provide pretrial services officer with date and location. So if you're supposed to be at Henderson Pass, then you're not supposed to be in Austin. And if you all are traveling when you play, if you're going to be in Austin, then you're going to be in Austin, but you're not going to go to the celebration.
Got you.
Okay. All right. All right, is there anything else? All right, your next court date. Norma, when is the next court date for Mr.? December 14th?
November 14th.
All right, your next court date is November 14th. We will see you then.
Thank you.
Judge, on that, we had requested medical reports, which we had been promised, we still had not received those yet.
All right, and I see that you've been requesting medical reports. That's been going on since July. Who is the prosecutor on? It's Marcus. When will Marcus be back? All right, so we'll come back on November 14th. And Mr. Coleman, you can appear by Zoom because I don't anticipate something substantive. And when I say substantive, I don't believe a disposition is going to happen on November 14th. It's just to make sure that your attorney has the record she's supposed to have. So you can appear by Zoom.
Yes, ma'am.
So we'll come back on November 14th for medical records and see where we are.
Thank you.
All right, thank you. Oh, yes. Yes, yes. Can you mute me, please, and stop video?
I get it.
All right, the court is calling 2022 CR 3263, State of Texas versus Samuel Ramirez. Can I have party approach for the record, please?
Catherine Pollard for the state. Mail County Roll here for Samuel Ramirez.
All right, and are you Samuel Ramirez? I'm gonna need you to speak up so I can hear you.
Yes.
All right, so Mr. Ramirez, the court reporter is taking down everything that everyone says. And if you don't respond, then she's not taking down anything. And I need to hear what you're saying, okay?
Okay.
All right, thank you. All right, the defendant entered a no contest plea on September 6th. And a TAP evaluation was ordered. According to the plea bargain agreement, the state is recommending deferred adjudication. The court has had a chance to review the PSI report. Have both parties had a chance to review the PSI report?
Yes, yes, Judge.
Any objections to the PSI report?
No, Judge.
All right, anything you wish to say on behalf of your client?
No, we just respectfully requesting the court follow.
All right, Mr. Ramirez, is there anything you wish to say to the court? All right. I have a few questions for you because you waive your right to remain silent. Could you raise your hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. So are you employed?
No.
So how old are you?
26.
How are you supporting yourself?
Financial.
Yes. No, how do you do that? Is there somebody else who's paying for you to have food, shelter, that clothing?
Savings and family.
I'm sorry?
Savings and family.
All right, so how much do you have in your savings?
I will not answer that.
I'm sorry?
I will not answer that.
Okay. All right, is there anything else from either side?
Nothing from the state judge.
All right, this is what the court is going to do. The court is going to follow your agreement. The court is going to sentence you to 3 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Amanda Ramirez. There's a $1,500 fine. That will be probated. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. 100 hours of community service restitution. The hostility and aggression course. MIC caseload if applicable. Regular reporting in person or by Zoom. There's been no unsupervised contact with minors. Field visits field visits will be 3 times per month until further notice. If probation determines after 3 months that field visits are not necessary, then probation can have those field visits as they deem necessary. There's to be proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. ISF, cognitive and substantive. Is there anything else with regards to sentencing from either side?
Nothing from the state judge.
I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own, or I'm sorry, because this is an affirmative finding of family violence, you're not allowed to own or possess, excuse me, sir, if you'll move. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
You're going to be taken into custody for transportation to ISF, and you're to remain there until you're transferred. Yes, I want cognitive and substantive.
Think about this. That this is a new misdemeanor, number one. Lady's taking it over there. She knows that.
Court is calling 2022 CR 10421, State of Texas versus Jonathan Ruiz. Can I have parties announced for the record for the state? For the defense? And Mr. Ruiz, if you'll come up. Are you Mr. Ruiz?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
If we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Ruiz, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of evading arrest, detention, second or more? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? You need to answer. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Okay, you're gonna need to speak up.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is recommending deferred adjudication. They're taking into consideration County Court Cause number 695678. There's to be restitution in that cause number to Jasmine, Jasmeen Romo, in the amount of $1,797.56. And there's to be no contact with Jasmine Romo. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, it is.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There'll be a top evaluation and 150 hours community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Judge. States Exhibit 1, all attachments.
No objection, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I request for the court to follow the agreement that we have with the state, Your Honor. Mr. Ruiz was born in El Paso, and unfortunately, he was in the foster children program system, Your Honor, and that's where he grew up, his foster parents. And so we're asking the court to consider that and grant him deferred adjudication, Your Honor.
All right, Mr. Ruiz, how old are you?
19.
Do you have any children?
Yes, ma'am, I got one.
Age?
A year.
Have you been employed?
No, ma'am.
Why not?
Just, I don't have an answer.
How you planning on supporting a 1-year-old? Who's feeding your child?
Right now, my baby mom.
No, the mother of your child. I don't like the term baby mama.
I'm sorry.
All right, so the mother of your child has been taking care of your child, so you have not been bringing anything to the table.
No, ma'am.
Let me explain you something. In life, you have to bring something to the table. Either you're bringing the table, either you're bringing the appetizer, the entree, the utensils for people to eat. Right now, with your 1-year-old, you're not bringing anything to the table. And that 1-year-old cannot support themselves. You understand?
Yes, ma'am.
And I used to do work in the foster system. And let me just tell you something about life. At some point, the choices you make are your own choices. At some point, you can't continue to say, my parents didn't raise me well, so therefore I'm going to continue to blame them. You got to start making better decisions. And breaking into cars is not an occupation. It's a crime. You understand?
Yes, ma'am.
People who are on probation out of this court get jobs. And I know that sometimes people just breeze over it and they don't realize it. But guess what? When you're on probation, one of the conditions of probation is that you support any dependent that you have. And your dependent is your child. You understand?
Yes, ma'am.
And if you don't want your child to end up in the foster care system, you had better start doing better.
Yes,
And if people want to have children, I'm always saying people want to be fruitful and multiply, then be fruitful and multiply. But you need to take care of your child financially and emotionally and teach them. And right now you're off to a horrible start for your child. So you're going to have to change that.
Yes, ma'am.
All right. Have you been using any drugs or alcohol?
No, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. Take in consideration County Court Cause number 6956778. Restitution and no contact with Jasmine Romo. And the restitution amount to Jasmine Romo is $1,797.56. How far did you go in school?
To 10th grade.
Why did you drop out?
Corona.
I'm sorry, what?
Once COVID came, I've never had a chance to go back.
That's no excuse. I mean, people are in school now. You're going to have to make a decision on what you're going to do with your life. Because again, crime is not an occupation. You understand?
Yes, ma'am.
All right, 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes with Triple T, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Where are you going to be living?
With the mother of my child.
Does she want you there?
Yes, ma'am.
And who is she living with?
She lives with herself. She has her own apartment.
All right, do not go to her apartment and mess up things for her. You understand?
Yes, ma'am.
There's to be no unsupervised contact with minors. I'm going to want field visits 3 times per month until further notice. I'm going to want the UA hotline until further notice. So you had better not be smoking marijuana or doing anything because we're going to find out. You understand?
Yes, ma'am.
And you either need to get your GED or do some kind of trade school to better yourself. You understand?
Yes, ma'am.
Probation, is there any, there's going to be regular reporting by Zoom or in person. And probation, if probation wants to, you can use the UA hotline as contact or either the field visits as contact for reporting. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
No, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. You're gonna have to start doing better, be a better example for your child. You understand? Don't have your child end up coming to court saying, I grew up in the foster system. You understand?
Mhm.
All right, good luck.
Thank you.
You're welcome. Who's here on Jesus Solis?
Right here, Judge.
All right, where's Solis?
He's back there.
All right, come forward, Mr. Solis.
We have him in the back.
He's in
back
the.
there.
he's back there.
Oh, what is happening with Mr. Solis?
I conferred with the state. We've got an offer. My client is thinking about it.
Okay. All right, Miss Ferguson, on Solis. Can we have a 3-week reset as a plea deadline date?
I can do December 8th.
All right, December 8th is your plea deadline date. Do you have all the discovery?
I just got the case 13 days ago.
Oh, you didn't tell me that part. Can I have a 30-day reset?
I can do December 19th.
Yeah. All right, December 19th will be your discovery date then, and your you can review the offer with your client.
Okay.
And then when we come back, I'll give you a plea deadline date.
All right, thank you.
All right, thank you. You should have started with, I just got the case. Who's here on Angel Cantu? Who's the attorney? Okay. Oh, just 1 second. I'm going in order. Gloria Orozco. All right, and where's your client? All right, come forward. What is happening with this case?
Judge, we've got the file with the DA this morning. They're just way behind, and so we're trying to get an offer from them.
And Judge, I was gonna give an offer shortly.
Yeah, he's doing the best he can. I get it.
Oh, no, everybody's doing their best,
Yeah.
which is great.
And so, but.
Miss, come forward, Miss Orozco.
And that's what we're looking for.
I'm just trying to know down the specifics. I was trying to look up the drug pieces.
Okay, no, that works. That works. Judge, it looks like we might be able to work out a pre-trial diversion on this, so. Which I think is kind of where the direction we're heading. So,
What time how long will that take?
Just a short amount of time, Judge. If you could just reset it, I can email defense the PDD conditions. It just jump from case to case.
All right, how much time do you need?
Just a week.
All right, Miss Ferguson, can we recall Miss Orozco in 1 week?
November 18th.
All right, we'll be back on November 18th. Miss Ferguson will give you a reset form.
perfect, Judge. Thank you, Your Honor.
You're welcome. Who's here on Justin Lamb? Okay, where are we on this case?
We filed the PTD application, sorry, the contract.
Okay.
It was signed, he is accepted into it. Contract was filed November 3rd.
Okay.
He went to report the same day, and they told him that he had to come back to court.
Yeah.
All right. So Ms. Ferguson, I need a PTD date. They've already filled out all of the documentation. And it's on Lamb.
I can do that December 19th, Jeff.
And may I inquire, because he did go to PT, he went to pretrial services.
Mhm.
The contract was signed, submitted. I normally get started orientation. I don't know why they told him to come back here.
I have no idea.
I'll just have him
Yeah,
follow up.
wait after the court and then contact PTD officers.
All right.
Sounds good.
All right. Thanks.
Thank you, Judge.
You're welcome. Okay. Yeah, just let him sit there. You know what? We can, oh, no, we can try him on another day. Yeah.
Judge, madam.
All right, just give me 1 second. What page is Lamb on? Do you see? Lamb?
On 11, I'm very sorry.
Thank you. And on Lamb, did you say the 19th, Ms. Ferguson?
Yes, ma'am.
Thank you.
All right, so everyone, I'm going in order in which I received your files. Jorge. Okay, I'm getting to it. All right. Who's here on Jorge Ortiz?
I am,
Yes, what is happening with this case?
Let me, first of all, I want to say that the district attorney has been more than cordial with me and very nice to me this morning. However, I'm extremely upset, which doesn't really matter. Let me explain to you what has happened. This offense allegedly occurred on November the 16th of 2021. His bond was set at $50,000. He made the bond, got out. On July 13th of 2022, his bond was increased to $100,000 for a case that has now been dismissed and gone away. He has been in jail since July 13th. He didn't get indicted until August the 18th of 2022. I have now come here 4 times, September the 16th, October the 24th, October the 25th, and again today on November the 7th. There is no offer in the DA's file. They have not given me all of
Okay,
this.
all right, so let's, I always tell everybody, let's keep it here. I understand the issues.
I will calm down.
Yeah, I mean, let's
Thank you,
bring it
Judge.
down. It's a Monday.
Here's what I
I mean,
mean.
everybody put some patience in the pocket. So this is what I have. I have that we were here on November 16th. And on November 16th, discovery was received. We were to come back on October 24th for the state to tender an offer. But I do believe, were we in jury trial?
Yes,
October 24th?
y'all were in that big trial.
Yes. So I mean,
All of October.
yes, so all of October, we were in trial.
Right.
So the fact that nothing no movement was on your case is more likely than not because we were in jury trial on a murder case. So then we come back on October 25th, according to my docketing sheet. And it was recalled for today. And someone's supposed to be speaking with the complainant. So first off, has the complainant been spoken to?
No, Your Honor, because there was a mistake in the police report. It's the witness who it seems, it wasn't indicated that they were the victim, but it made it sound like that. So the wrong person was contacted, so the victim still needs to be reached out to.
Okay. So state, how long will it take for you to reach out to the complainant?
Not long, Your Honor. I have already asked our victim advocate to call the correct person.
All right. Now, with regards to the bond increase for the new case, There's nothing I can do about that because we'll need to have a hearing on that. And I'm not the one who increased the bond, I don't think. And I don't have access to the information to make a decision on what his bond should be posted at. So that's where we are. So, Ms. Ferguson, are we able to have Mr. Ortiz come back in approximately 2 weeks? Is that enough time?
That should be enough time, Your Honor.
All right.
I can have it back in the. I can have them back on the 17th.
All right, so we'll be back on November 17th. All right, Mr. Ortiz, we will see you then.
May I be excused?
Yes,
Thank you, Judge.
you're welcome. All right, who's here on Isaiah Verhu?
Your Honor, that would be me.
Yes. Come forward. What is happening with this case?
Yes, Your Honor. This is my personal first setting on the case.
Welcome.
Thank you. I appreciate it. I am coming to join Nate Navy on it with Dunham and Jones. So I need time to be able to meet with Nate and be able to look at what Nate has in our system to see what evidence has already been tendered. I've been conferring with Michael. There may or may not be CPS case records that have already been disclosed to our office.
No, it has been on June 13th. It says CPS records in ADA possession, phone data in ADA possession.
Correct.
Appointment to review video, July 21st, state will make offer. July 21st, offer tendered, discovery received, defense reviewing discovery. And then we were back on September 6th, and you were given a reset for today.
Okay, so I was not, thank you for the update, but I was not present for those, so I'll still need to meet with Nate. The other thing is that I've been speaking with Mr. Villarreal. There may be some question on whether or not the CPS case records are the complete files. Mr. Villarreal was going through them, and they're only pertaining to this particular incident, where it sounds like there may be family involvement that predates this information.
All right, Ms. Ferguson on Verhu. Let's reset this for 45 days. You all need to have worked out the CPS issues, and that will give you a chance to catch up on things.
Thank you. And that's exactly what I need. And I will speak to Michael ahead of time once I've reviewed it from Nate's end to see if there is something additional we need.
I just, maybe there's a misstatement of miscommunication rather between us two. I believe that the CPS records as they relate to Texas are complete based on our subpoena. Defense attorney has brought up, and this is also within the state's knowledge, some other issues involving a different child, different defendant, unrelated, that happened in another jurisdiction, from my understanding. And so that I believe are the records that she's seeking. And so I don't have, those are not clearly within the state of Texas possession as I understand it, but I'm more than happy to continue working on that issue if in fact they are within the state of Texas's possession.
Okay. So usually, I mean, if it's another defendant, it's not going to show up in the CPS history. So,
Well, but it should under the mother, if the mother was one of the people that was identified as a possessor of the child. So it should have come up under there.
possibly.
Possibly, which is again, why I need to go back and look at what's in our system. And then we would go forward and looking at, is this need to be a request that would go through the district attorney's office, or do we need to get an investigator to subpoena the other?
All right, I'm going to see y'all back on December 19th. If it needs to go through somewhere else, somebody needs to have subpoena whomever they need to subpoena.
You're on, thank you.
All right, thank you.
May my client be excused.
Yes.
Thank you.
All right.
I'll meet you.
Who's here on Brian White? Brian White. All right, so I guess they are not here. Oh, okay, all right. Court is calling
Can't move very fast. I've got arthritic knees.
Oh, I know that's painful. The court is calling 2022 CR 8045, State of Texas versus Brian White. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Julie Pollock.
And are you Mr. White?
Yes, ma'am.
Showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, yes.
Court will find that the state is in compliance with discovery. Mr. White, I'm showing you what's entitled application for community supervision. Did you review this with your attorney? Did you understand it?
Yes, ma'am.
All right, this is checked off that this is not a plea agreement.
Oh, I'm sorry.
I always tell people, everybody, please leave the trial court certification unchecked because I'm the person who checks that.
I informed him that it is a plea bargain, so he has no right to appeal.
All right, Mr. White, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. White, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of driving while intoxicated third or more as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. White, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you what's entitled the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I do.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. The state recommends community supervision. This is run concurrent with County Court Cause number 645329. Restitution, if any, DWI intervention, VIP live, ignition interlock for 2 years, 2 years Texas driver's license suspension, and 10 days in the Bexar County Jail as a condition of probation. Did you understand that to be the plea?
I did.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor. I'm sorry.
Have there been any such motion?
I have filed some motions, but my client wants me to waive those motions.
And those motions have not been heard?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State, any evidence?
Your Honor, state offers state exhibit 1 in all attachments.
No objections.
Mr. White, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence state exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
We would just ask that you follow the agreement. Now, my client, he's done approximately 120 days in jail before he bonded out. We would ask that you give him credit for that time he spent to satisfy the 10 days in jail. He lost his job while he was incarcerated. He currently has a job. He makes 15 an hour. He's got a 14-year-old son. He's a sole caregiver. His son is doing much better since his dad is out with him. He's on the AB honor roll now, and things are looking up for him. We would just ask that you allow him to continue to be out with his son and be on probation. I think he will. He's going to AA meetings now. He's taking care of the issues that he has. So we would ask that you follow the agreement.
All right, how did you get here today?
I was given a ride by my dad.
Where's your dad?
He's at home now. I can take the bus.
Okay.
But Your Honor, I am 5 months sober. Like she mentioned, I was incarcerated for over 90 days, and since then I have abstained from alcohol and continuing to go to AA meetings. And being away from my son for that long has kind of put things into perspective. So no intention of going back to drinking. Part of that was being in a toxic relationship. I'm divorced after 16 years.
Here's the thing. You can't blame.
I'm not blaming. I just, it attributed to it. My wife is still continuing to struggle with her substance abuse issues and is not in my son's life. And I don't want to be the same.
So basically you both were not sober.
While we were together at the end of our relationship, yes.
All right, this is what the court is going to do. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years, $1,000 fine, probated, concurrent with County Court Cause number 6455329, DWI intervention, VIP live, ignition interlock for 2 years, 2 years Texas driver's license suspension. There's to be 90 sober meetings in 90 days, 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 hours will be waived. Parenting classes, the remaining of the hours will be waived once you complete parenting classes. There's going to be regular reporting by Zoom or in person. I'm going to want field visits once per month. Probation, we'll do that for 3 months. If there's no issue, then you can do field visits as needed. I'm going to want a TAP evaluation. If the TAP evaluation recommends inpatient treatment, we'll start off with intensive outpatient treatment. If it doesn't recommend any treatment, then I'm just going to want regular outpatient treatment. There's going to be 20 days GPS partial for employment in lieu of the 10 days in the Bexar County Jail. And I'll ask that the fees are waived. Probation, is there anything else he needs? Proof of employment. Within 30 days, there's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Thank you. And we'll do regular UAs. And make sure they test for alcohol. All right, is there anything else you need from the court in order to be successful? All right, and I believe we still have the trial court certification.
It's right there.
Judge.
Ah, thanks. Okay. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. You understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. Here's the thing. This is what I've discovered. My statistics professor will be disappointed in me because I haven't done an actual study of it. But usually when people are driving intoxicated and they end up getting in a car accident, you know who ends up getting hurt? Their passenger, somebody else. It could have been you driving and your child is in a car with somebody else and you end up hitting them and killing them. Don't be that person. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Who's here on Angel Cantu? All right, so call him and tell him if he leaves, then this case is going to be recalled for another day. All right, who's here on, I've already done Justin Lamb. Why do I keep getting this back? Who's here on, Jaime Santos?
Lauren Lefton.
Went to the 399.
All right, then.
Withdrawing that.
Are you withdrawing it?
Yes.
Okay. There you go. All right, everyone, you have 5 more minutes. So if you have something, you need to approach now.
Yeah, approach Judge.
Yes.
I'm Eric King, he's an MTR.
Mhm.
I know the court's pretty much,
Fine.
I'm sorry.
That's okay.
Old habits. die
That's okay.
hard.
Yes, what is happening with King?
I think we have an agreement with the state, Mr. King. Is still in the back. Yeah, she just got here, so we never had a chance to bring it up.
All right, so everyone, these are the rules of the 187th District Court, just so everyone is aware. At 11:40, is it 11:45? That everybody goes back?
So 399 couldn't let her go. I recalled.
No. 11:45, everybody who's an inmate goes back. So this is the last day that inmates are still going to be sitting in the box. At 11:45, they're all going back.
Can I go back with him?
Sure. We can outfit you.
We're not gonna get. not do that. Just come.
All right, Cantu. Angel Cantu.
Yes, I'm here on that.
All righty, Mr. Cantu, come on up.
I'm sorry, Judge, what are we gonna do on Mr. King?
All right, just give me a second.
Sure.
All right, are you ready on Mr. Cantu?
The state is not ready there one more time.
All right, State, what is happening with Mr. Cantu?
Judge, his new number 1 just occurred 25 days ago.
Okay.
So we need to reach out to the victims in that case.
All right, Ms. Ferguson on Cantu, I need a contested setting.
We're looking at the first week of December, please. I have a vacation letter for the end of November.
Okay,
We're gonna do December 12th.
all right, December 12th.
Thank you, Your Honor.
You're welcome. And how many witnesses?
I guess I have not read a file. I don't know anything about nothing. But I'll figure it out. I think I'll have one. Him, his
Okay,
grandma,
all right, so, all right, it'll be at 11 a.m.
11 a.m.
Yes. Yes, so what is happening on King?
Judge, it's an MTR. I think we have an agreement. I don't know if the court wants to rescind until later in the week or another date.
Deputy Laura?
He's downstairs. You can bring him if you want him.
All right, go ahead and bring him.
Thank you, Judge.
Your Honor, may I approach?
On a case that's on the docket?
Yes, Your
Do I have the file?
Honor. You should, Dario Escalante.
Did you request that the clerk give me the file?
No, I did not, Your Honor. I'll request that now.
Santos?
Who's here on Dario? Where's Dario Escalante? Come forward. All right, today is the plea deadline date. What is happening?
Judge, we have a plea agreement for 2 years. I have
All right.
the paperwork here.
All right, as soon as you get the paperwork done, we'll do it.
The judge, Mr. Escalante, is asking for some additional time to take care of closing out his business, taking care of moving his sister to a new location. We're respectfully requesting to go ahead and enter the plea today because the
All
court,
right, you all need to get the paperwork done.
we haven't,
It's been sworn in.
Judge, we haven't finished getting the signatures on the paperwork yet.
All right,
So my request is that the court delay sentencing for at least a few weeks to the end of November.
I've been in Parker Heights, which is out there by Colleen. And I got a lot of my tools and stuff that I.
here's the thing.
Yes, ma'am.
I'll take that up when it's time for me to
Yes,
take
ma'am.
that up.
Yes, ma'am.
So if y'all do the paperwork, then the court will hear it and we'll go from there.
Yes, ma'am.
Thank you, Your Honor.
Yes, ma'am. Thank you, ma'am.
You're welcome.
Yes, ma'am.
Jenna Rodriguez.
Excuse me, President Burr.
All right,
She answered the document. Her and I were conferring out in the
Where-
hallway.
oh,
We
okay,
were
sorry.
conferring out in the hallway for at least 20-30 minutes earlier. Came in here to confer more with the prosecutor, went back out there and I don't think she's still in the restroom because it's been a while, so I don't know where she is. Judge.
All right.
Just to be honest, I don't know.
All right, court is calling 2022 CR 8415, State of Texas versus Jenna Rodriguez. Can I have parties announced for the record for the state,
Michael Villery, State.
for the defense?
Todd Coronado.
All right, this hearing was scheduled at 9 a.m. It is now afternoon, 12:24 p.m. The defendant was a no-show on November 1st, so the court recalled this for November 7th. Counsel, where's your
was-
client?
She was here today.
Mhm.
She answered the document.
And she left, she's no longer here.
Yes.
State,
You're at this time, state moves for a bond forfeiture and a warrant should be issued for the defendant's arrest.
that'll be granted. Your client will be remanded without bond. If your client makes an appearance, then the court will reconsider.
Thank you, Your
All
Honor.
right, thank you.
I've excused.
Yes.
Thank you.
Hey, sorry.
All right. Can I see the files on? Oh, just 1 second. What is happening with Armando Jimenez?
Yes, Your Honor. There's some discovery issue, Your Honor. We're trying to go through the videos and see. Some may be missing. I have some from another case.
I'm trying to just double check and see.
So what is going to be happening with the case?
Well, I need to see that the videos may be missing. See if we're going to do a motion on the case.
Let me see the file on Jimenez.
We've gone through all the videos that I have.
And Judge, I'm trying to go through the videos that we have. There's one that I think it resolved the issue, but it's taking a second just to.
It's Armando Jimenez. Oh, you can just give me the files.
Yeah.
It's Armando
Yeah,
Alejandra Jimenez.
yeah, I don't have them.
Okay, that's fine, that's fine.
I have one to stop.
You've given me key now. All right, here we go. All right, Miss, how much time do y'all need?
Judge, we're discussing it right now. It shouldn't be, I would say, 3 weeks,
All right, Ms. Ferguson, can I have a 3-week reset on Jimenez, please?
just because we're just trying to figure out what the exact issue is going on.
Okay, and what is the discovery?
Discovery issues on the ones I downloaded. Some of the videos are from a different case. And I'm missing some videos.
So they're all videos?
Yeah, and they have the same last name, so they might have got this mixed, and they're like 2 days apart on the date.
All right, we'll be back on December 1st for discovery. Who's here on Jason Hickman?
Or
All right.
client had told me his wife had submitted a letter. This is the bond hearing.
I don't see that letter in there.
All right, so we'll have to do it on another day.
The criminal history in there, Judge. Did we request beforehand? When he had requested that we get criminal history.
Mhm.
I don't have the defendant's wife's letter.
All right, so we're calling on another day. When will we come back?
Hopefully you don't need more than a week, maybe.
I can
Just a
check if
bond
it's in
hearing.
Maybe.
All right, let's just call it on another day. When do you want to come back?
December 1st, I guess.
Is December 1st okay? Or you want to?
Well, I don't think we need to wait that long.
I don't know. I have no idea how she.
If that's all we're waiting on, just,
Okay, what day? He wants to do a date sooner than December 1st.
Yeah, that's 3 weeks away. I don't think we need to worry about that.
Well, when she sent that letter.
How should it send that?
I can do November 17th.
All right, we'll be back on November
That'll work.
17th.
That'll work fine.
She can bring it to, you know, her to bring it with her to court.
I'll contact her. There, I don't get copies of those, that's a problem.
Yeah.
I find out when I look at the files sometimes.
Okay, all right, November 17th.
I don't know.
Your Honor, can we send James Stochi's client back?
Yes. Give me all the rest of the files that we still have left. Who's here on Keno Jimenez?
You know, I just stepped out a minute ago to put money in his computer. But I have an update on that as well. Judge.
All right, what are we doing with his case?
He's gonna plead on the new number 1 today in County Court 6 that we're set for, and my understanding from the state is that they're gonna withdraw the UTR in this.
All right, so and when is he pleading?
This afternoon.
All right, Ms. Ferguson, on Keno Jimenez, we're gonna recall that tomorrow. If he hasn't pled, then we're taking up the. Oh, that's, sorry. We're gonna recall that on the 9th.
He was set to be here on the hearing on the MTR on the 14th, Judge, a week from today, either way. If it's okay with the court, if it's withdrawn before then,
Yeah, so that's why we're putting it on the 9th.
okay, that's fine. So if it's withdrawn, then he doesn't need to.
Yes. Yes,
Okay, thank you, Judge.
you're welcome.
Mr. Martinez, go for it.
Okay, where is it? No, so it's Julian Martinez.
Yes.
You can send him back. Which day do you want to call him back, Norma?
Whatever day you want. Yeah, we're not waiting for anybody.
Yeah, put him on the 9th. All right, Robert Beltran. All right, Norma Beltran, the 9th.
She's taking the.
All right, who's Dario Escalante? Okay. Who's here on Angel Galindo?
Yeah.
Okay, thanks. All right, Norma, on Angel Galinda. Can you put that for a 30-day reset?
Number 8. Is that on the violation report?
No, that's just for the actual case. Because is there sitting already on the actual case?
Let me check. If it was stuff for the violation report too.
All right, because the violation report, I'm just going to go ahead and do something else.
He said on November 17th.
Okay, all right, we'll keep it at November 17th. All right, who's here on Isaiah Gonzalez?
Isaiah Gonzalez, he's a third judge.
Okay,
He never showed up.
all right, and is there a warrant out for him?
Yes.
Oh, all right, thank you. Oh, sorry, let me put it here.
He has a violation.
Rudy Gonzalez. Rudy Gonzalez.
He's in jail, Judge. Probably was gonna be on his way, but.
Yeah.
He's back in another court.
All right, he can come back on the 9th.
All the way straight.
Tyrone Lard or Laird, come forward. All right, we're going to bring you back on the 9th, okay? And Norman, can you let Mr. Brobby know?
Mr. Robinick is sick, Judge. He just texted me. She wasn't able to make it because he's sick.
All right, is he able to appear by Zoom or no?
Yeah.
Are you employed? Are you employed? Well, how are you supporting yourself? How are you supporting yourself?
Well, I do little side jobs.
Okay. Just, Norma, then we'll reset it for 2 weeks. Do you have your attorney's contact information?
No.
All right, we'll make sure you have that.
I can do the 28th, Judge.
All right, so we're gonna come back on November 28th. Ms. Fergus, can you put Mr. Brovanek's contact information on the reset form? All right, we'll see you then. All right, Joe Lopez. Who is Nancy Bierman?
He's an attorney from Dallas or Houston.
Nancy there.
Yes.
She's right from here. I don't see her, but she's from here.
I thought just. Oh, maybe mixing her up with someone else.
All right, Norma, on Joe Lopez, we'll bring that back on the 9th. Ernesto Lozano. All right.
Roger said that he's a truck driver, if he can come in on Friday.
No, because he was a no-show on November 1st. So let him know that a BF is going to be issued.
Documentation. Thank you. It's a 2-year.
All right, can I have a prosecutor? Britta, you ready? Court is calling 2022 CR 7740, State of Texas versus Ernesto Lozano. Can I have parties announced for the record for the state?
Brittany Sparks.
All right, this hearing was scheduled at 9 a.m. is now 12:39 p.m. Defense attorney is a no-show, and the defendant has not been in the courtroom. State,
We does the forfeit his bond and issue a warrant.
that'll be granted. The defendant will be remanded without bond. The court will note for the record that the hearing was scheduled on November 1st, but the court did not issue a bond forfeiture at that time, even though the defendant did not appear, and a November 7th date was requested. Who's here? Maria Medina. All right, the court is calling 2020 CR 3303, State of Texas versus Maria Medina. Can I have the state announced for the record?
Brittany Sparks.
All right, this hearing was scheduled at 9 a.m. It is now 12:40 p.m. Defense attorney is not present. The defendant was scheduled to appear on July 14th. The defendant was a no-show. Then the defendant was scheduled to appear on November 1st. The defendant was a no-show. And the court gave the attorney time to see if he could contact his client. And that is why we're here on November 7th. State, that'll be granted and the defendant will be remanded without bond. All right, who's here on Eric King? Court is calling 2019 CR 12900, State of Texas versus Eric King. Could I have parties announced for the record for the state? For the defense? And are you Mr. King?
Yes.
All right, Mr. King, I'm showing you with the entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand?
Yes.
Are you the same Eric Michael King who was placed on community supervision in 2019 CR 12900 for the offense of violation of sex offender registration annual on March 4, 2020 for a term of 5 years? Is that you?
Yes.
State?
Substance.
How do you plead to that? True or not true? Any objections?
No, ma'am.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 5 years in prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there an agreement?
That is correct, Your Honor.
Will ISF accept him?
It is, it's probation.
All right. Excuse me, Ms. Abrams?
Yes, Your Honor, I'm looking at it right now.
All right, thank you. Okay.
Here's the thing, well, Your Honor.
All right, the court will follow your agreement, alter the main conditions to include ISF substantive track. Is there anything else from
No,
either
ma'am.
side?
No, ma'am.
All right, defendant is to remain in custody until transfer.
Thank you, Your Honor. May
All
I
right.
be excused?
Yes.
Judge, just have a seat, sir. Mr. Bobbitt's not gonna be, he has a letter on file till the 20th. So we
Okay. So you want to November 28th,
29th.
29th? All right, thank you. And what date did we give Joe Lopez? That's what Nancy Bierman.
So we gave him the 9th.
Okay. Let me make sure that's everyone. All right, and Maria Medina?
Yeah.
Yeah, okay. All right, and then we have Caleb Coleman, that's been done. Manuel Sandoval, that was done. Angel Galinda, that's been done. Rafael Guerra, I didn't see the but VR on him. Ah. There we go. Yes, just 1 second. Yes.
I've got Julian Martinez. This is one where we had taken testimony last week. You were just gonna bring us back and tell us what the court had decided.
Yeah.
It's been a crazy Monday, and then this was recalled from Friday into today. It's the earliest I could get here.
Okay.
Judge, his mother's here. This is the second time in the last week she's taken off of work for here. I don't know if the court's ready to pronounce its judgment, or I know you had recalled it for the 9th, but
Yeah, they've taken him back.
Okay.
If the mom can appear by Zoom
Okay,
and we can make it happen on tomorrow. I'm sorry, not tomorrow, the 9th.
okay.
Yes,
And then I'm out of county that day. Can I appear by Zoom as well?
yes.
Okay.
All right, thank you. Monday is always a crazy day. Yeah, that's what it's-
The bench trial.
Or December 9th.
Oh, Wednesday's our bench trial. It's all fluid.
You know, I'm gonna start saying that, Judge. What state's recommend, Judge is all fluid.
It's all fluid. You know what? As long as people smile, and have patience in their pocket, it will go well.
Well. Right? I'm meeting with two people this afternoon, so maybe it will be.
All right, the court is calling 2022 CR 6753, State of Texas versus Dario Escalante. Could I have parties announce for the record?
Robert Featherston representing Mr. Escalante.
You, Mr. Escalante?
Yes, Your Honor.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Escalante, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving count 1 as well as the enhancement paragraphs, proceeding solely on count 2.
Any objection?
No objection, Your Honor.
Mr. Escalante, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
With the state's waivers, you're charged with possession of controlled substance, penalty group 1, 1 gram to 4 grams. That's a second degree felony. The range of punishment is anywhere from 2 to 10 years, 2 to 20 years in prison and up to $10,000 fine. Just one moment. Are you proceeding on any of the enhancements?
No, Judge.
Possession 1 gram to 4 grams?
It's 1.4 grams of methamphetamine.
Okay. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have see, that's why I'm like, this is not right. I was like, maybe there's some new law that I'm not aware of. Okay. All right. Did you understand that the range of punishment for the offense you've been charged with, it's a 3rd degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Brenna? Because I was like, maybe there's a brand new law. And I just missed that in school. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Escalante, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, punishment is to be assessed at 2 years in the prison. There are no applications. If you do not show for sentencing, you will be subject to the full range of punishment. Do you understand?
Yes, Your Honor.
And in this case, do you understand that the full range of punishment for you would be a minimum of 25 years
Yes, Your Honor.
with a maximum of life in prison? Did you understand?
I do understand, Your Honor.
Did you understand that to be the plea, Mr. Featherston?
Yes, Your Honor.
State.
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in count 2 of the indictment. How do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence?
Yes, Judge. States Exhibit 1 and all attachments.
No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations.
Yes,
Did
Your
you
Honor.
review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And the court will find you guilty. Are we proceeding with sentencing?
Your Honor, if it please the court, we're respectfully requesting that the court sentence at another date. Mr. Escalante needs to close down his business and secure his tools. His sister also has some surgeries planned and needs to move locations. And we're requesting some time for him to be able to do that. He has also been admonished that if he fails to show at a later sentencing date, that the full range of punishment will be available.
All right, how much time are you requesting?
Your Honor, if we could do it near the end of the month, I need to make the court aware that I have to go to Comell County on the 28th of November for a super aggravated sexual assault case. It's 4 years old. It's gonna go
Oh, so that's a jury trial.
jury trial. And then on the 5th
So,
of December,
so we will need to do it before that date.
before that date or in January.
Oh, no, we'll do it before November 28th.
Thank you.
All right, Ms. Ferguson, I need a date before November 28th.
Judge, will be next week. Because
Okay. Yeah, it will be next week. So we can put it on the 18th.
18th,
Yes.
is that gonna be enough time?
Yeah, all right, I just found out about my sister. She's having some problems with her
Let me ask you this. If I drug test you today, what are the results going to be?
positive.
So we'll be back on November 18th.
Okay.
And here's the thing, by us coming back on November 18th, I may be saving your life. Because whenever you do drugs, guess what ends up happening? You never know what you're going to get. It's not FDA approved. And the last thing your sister needs on her plate is her brother overdosing. So my advice to you, and I know your attorney will speak to you about this because I know he is aware of the treatment courts. My advice to you is when you walk out of this building today, you need to get in an AA or NA meeting and you need to stay in that.
I was clean for 7.5 months, and I thought I was gonna get 10 years, and everybody's telling me this 10 years, stuff like that.
So your thing was, I may get sentenced to 10 years, so let me go out and party beforehand?
No, I was just depressed. Was in a.
Judge, he has a long-term history of fighting methamphetamine.
So you're gonna have to be stronger, and you're gonna have to leave here. When you leave here,
Yes,
you
ma'am.
need to go,
Yes,
and you need to go to a meeting
Yes, ma'am.
and not leave here and use. Because guess what? Your sister, your family, whatever they're going through, they don't need the extra pressure and extra worry of worrying about their brother and worrying about whether or not if their brother uses this time, this is gonna be the last time because he's gonna die. So if you want to help them,
Yes, ma'am.
that's the best way you can help them. And many times people will ruin their sobriety, but guess what? That's just one day in your life. You get back on and you get sober again and you start back over from day one. You understand?
Yes, ma'am.
All right, we'll see you then.
Thank
Thank
for
you,
your-
Art.
Thank
for
you.
your advice, ma'am.
You're
I
welcome.
appreciate it.
You're welcome. All right, I think that's every case that we have. So we will be back on Wednesday. So see everybody then.